Yep, okay, great. We will kick off then. Good morning, everybody, and welcome to the Senate Education and Employment Legislation Committee hearing into the Fair Work Amendment Protecting Penalty and Overtime Rates Bill 2025. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past and present, and I extend that to any Aboriginal people who might be joining us in the room today. The committee is conducting today's hearing both remotely and in person. That means we have some senators joining us by phone, so if you hear a voice pop out of nowhere, that might be Senator Mulholland or Senator Barbara Pocock. In the room we have Senator Kovacic, the Deputy Chair, Senator Lager and myself as Chair. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to this committee, you are protected by parliamentary privilege. It is unlawful for anyone to threaten or to disadvantage a witness on account of evidence given to this committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses have a right to request to be heard in camera, which means to be heard in private by us. If a witness objects to answering a question, they should state the ground upon which they're objecting, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera as well. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. This is an extension of all of our workplaces, and I expect it to be treated with the same kind of respect and diligence and professionalism. I also remind committee members and witnesses who are appearing via teleconference and who are not speaking to please mute your microphones. I would now like to welcome representatives from the Australian Council of Trade Unions, from the Australian Services Union Shop Distributive and Allied Employees Association, the United Workers Union and the Finance Sector Union of Australia. I understand that information on parliamentary privilege has been given to you all. For the Hansard record, I'm going to ask each of you to state your full name and the capacity in which you're appearing today. We'll just go from this end to that end in order. Thank you.
My name is Vince Ticito. I know it says Vincenzo. I prefer to be called Vince. I'm a delegate with the United Workers Union and member of the union.
Hi.
Hello. Well, my name is Noel Ward. I'm 28 years old and I'm a delegate for the United Workers Union and a school cleaner.
Great.
My name's Larissa Harrison. I'm the director of the United Workers Union's legal and research teams nationally.
Thank you.
My name is Nicole McPherson. I'm the National Assistant Secretary of the Finance Sector Union.
I'm Ben Moxham, the Director of Legal and Policy at the ACTU.
Great.
Hello, I'm Emmeline Gasky. I'm the National Secretary of the Australian Services Union.
Morning, my name's Sue Ann Burnley and I'm the Director of Industrial with the Shop Distributive and Allied Employees Association nationally.
Hi, my name's Emily Dick. I'm a delegate with the SDA for Office Works.
Hi, I'm Ruth Sumner. I'm a delegate with the SDA and work in retail at Coles.
Great, thank you, and welcome to all of you. There's now an opportunity to make a brief opening statement for whoever at the panel wishes to do so. Once you've made your statement, then we'll be rotating between senators who will ask you questions. So who would like to kick off? Is that you, Mr Moxham?
Yep, just a brief statement. Thank you, Chair. And I too acknowledge that I'm on the lands of the Wurundjeri people of the Kulin Nations and pay respects to their elders past and present. Senators, if a worker is working nights as a personal care attendant or serving meals on a public holiday, stacking their shelves deep into the evening or working well beyond their ordinary hours, they deserve their penalty rates. Getting additional pay for working those difficult hours when everyone else is putting their feet up is surely at the heart of fairness in this country. But the rights of Australian workers to be paid overtime and penalty rates are at risk through applications by employers in the retail, finance and clerical sectors to vary those awards by inserting exemption rate clauses. An exemption rate is a higher rate than the base rate of pay in award that is paid in exchange for an employee foregoing their penalty rates and other entitlements. In this case, however, if successful, these applications would lead to significant reductions in pay for the workers concerned, and we have no doubt that employers in other sectors would seek exactly the same outcomes. So, Senators, that's why the ACTU and all of our affiliated trade unions all welcome this bill. It's an essential measure to protect penalty and overtime rates. I'll make a few brief remarks about the bill before my friends from the ASU, FSU, SDA and the United Workers Union will speak to what this bill means for them and their members and the threat to them of their current employer cases on foot. Senators, this bill is very simple. It inserts a principle into the Fair Work Act that requires the Fair Work Commission, when it's exercising its powers to make, vary or revoke a modern award, to ensure just two things. Number one, that the rate of a penalty or overtime rate that employees are entitled to receive is not reduced, and that awards do not include terms substituting employees' entitlements to receive penalty or overtime rates where this would have the effect of reducing the additional remuneration that any employee would otherwise receive. So the bill would leave it to the Fair Work Commission to assess whether specific modern award terms satisfy the principle in each case that comes before it. Some employer submissions to this inquiry think that the bill prevents any exemption rates in awards. The bill does no such thing. It just requires that any exemption rate before the Commission has to ensure that it's high enough to effectively cover those penalty rates and overtime rates foregone, to make sure they do not, and I quote yet again, have the effect of reducing the additional remuneration any employee would otherwise receive. Some critics have also said that the bill restricts flexibility, productivity and employee choice. Again, the bill does absolutely none of these things. To claim that it does is stretching the English language to breaking point. Employers can still make exemption rate applications if they pass the test in the bill. They can still bargain with unions for collective agreements. They can still negotiate individual contracts above awards. They can still agree flexible work arrangements. The Fair Work system in Australia has a whole lot of avenues to achieve flexibility. The only thing employers won't be able to do is to pay workers less for their penalty rates as a result of this bill. Finally, some have claimed that the bill interferes with the Commission's role as the independent umpire. This is to misunderstand the role of Parliament and the Commission. Parliament has set and occasionally adjusts the statutory criteria which guide the exercise of the Commission's award-making, variation and revocation powers. Parliament did so recently in 2022 by introducing a gender equality objective into the Fair Work Act and the Modern Award objective, and this has triggered Commission work to deliver life-changing pay rises for workers in a wide range of female-dominated occupations. Parliament realised that our former equal pay laws were broken. It listened to the Australian people and it's acted to fix them. This bill is following a similar trajectory, and it's another necessary step given the current threat to penalty rates by these employer applications. Senators, there's a range of other more technical issues raised about the bill by other parties and more that we can say about who relies on penalty rates that I'd be pleased to address in questions. If it's okay, Chair, I was going to throw over to my other friends on the table for their statements and then take questions.
Yes, that's
how
we'll do it. So we'll do all statements and then we'll go to questions.
So I'll hand over to Emmeline Gaskey,
Thank
National
you.
Secretary of the ASU.
Hello. Thank you for the opportunity to speak today on behalf of the Australian Services Union, which is a union of over 135,000 workers across local government, community disability services, public services, airlines, call centres and administration workers all around the country. We strongly support the passage of the bill and we strongly believe it needs to happen as soon as possible, given there are presently cases on foot seeking to cut penalty rates of workers in this country. And we know penalty rates and overtime are not a luxury, they are a lifeline. They compensate workers for sacrifice of working nights, weekends, public holidays when others are resting or enjoying recreation with their family and friends. These are times that impact on families, communities and personal well-being. And for workers who rely on penalty rates, they are absolutely essential to making ends meet and putting fuel in the car. They need to be protected and we need to act now. Right now, the Australian Services Union is defending two applications in the Fair Work Commission that seek to remove penalty and overtime rates from the Clerks Private Sector Award that have been made by AIG, ABI and Business New South Wales. These proposals are seeking to introduce these so-called exemption rates, which would allow employers to bypass rostering rules, breaks, most critically the requirement to pay penalty rates and overtime rates. And if successful, they would also eliminate the need for employers to keep time records, which would open the door to exploitation and unrecorded work. I just want to give you an example of one member that, the impact that would have on her take-home pay. A full-time administrative worker in an office here in Melbourne who's earning just $67,000 a year. Currently routinely performs about 6 hours of overtime each week, which is spread over a couple of days, and that overtime adds about $300 a week to her pay packet, so almost $15,000 a year. Under the AIG proposal, her base salary of $67,000 a year is apparently so high that she no longer ought be given or paid for those overtime hours. They should be considered part of her rolled up rate. And so she would lose that $15,000 a year in her take-home pay. And I think that's outrageous, and that is not what our industrial relations system is set up to do, and that's why it's so important this legislation is passed. On the question of the time and wages record keeping, we've made a recommendation that would strengthen the bill's effectiveness with an amendment to the Regulation 3.34 of the Fair Work Regulations, which would then explicitly require employers to keep time and wages records, even if an exemption rate, however it is called, is in effect. So at the moment, the requirement to keep time and wages records only applies to employers if they are under an obligation to pay penalty rates or overtime rates. And that is one of the reasons that big business is making these applications in the Fair Work Commission, because once an exemption rate is in place, they no longer have an obligation to pay overtime or penalty rates. And therefore, the regulation requiring them to keep accurate records of the hours worked and the wages paid to employees is no longer in effect. And so it would also make it very, very, very hard to scrutinise or test any exemption rates arrangements that are in place if there are no accurate time and wages records in place. So, for example, under the ABI and New South Wales Business Chamber proposal for the exemption rate, they say that an employee's weekly hours would be capped at 50 hours a week, so that there is a maximum of 12 hours of overtime worked without being paid as overtime during the course of the week. But the mind boggles as to how that could ever be effectively scrutinised in circumstances where the employer no longer has an obligation to keep records of the hours that the workers are working and the wages that have been paid to them. So we think that's a really common sense amendment that would take this one step further of ensuring that if there are successful exemption rates applications made in the Commission, and the Commission uses its discretion to determine that it's appropriate in a particular circumstance, we still have those records. That means that we're able to go back and scrutinise that and have a level of accountability on employers that it is doing what they promised it would do. We urge the committee to pass the bill swiftly, and we recommend the regulatory amendments to ensure employers remain accountable. We think that goes no further than making sure that the exemption rates that are approved by the Commission under the amended legislation would ensure that they're being applied in the way they're intended. And, frankly, workers cannot afford a pay cut, and putting some common sense rules in place to make sure that workers who rely on penalty rates to put food on the table for their families can't have them taken away by big business needs to happen as soon as possible. Thank you.
Thank you, Ms Gasky. Is anyone else seeking to make an opening statement?
Yes, I think I'm next.
Yes, Ms McPherson.
Good morning, everybody. We completely agree with the ASU. This is an incredibly important piece of legislation for finance workers. The FSU covers people working in banking, insurance and superannuation. As we know, banking is one of the most profitable sectors in our country, so it was very surprising to our union when the same group of employer lobby groups that Emmeline just mentioned, ABI, AIG and Business New South Wales, tried to introduce an exemption rate into the Banking, Finance and Insurance Award. This exemption rate proposal from them has very similar terms to what Emmeline just set out, and this would effectively cut incredibly important penalty rates of finance workers. There's a bit of a misconception about finance workers. I think when people imagine a finance worker, they think about, the Commonwealth Bank's profit announcement this morning where they made record profits of over $10 billion a year, and they think of those people. But really, when we're talking about award-covered finance workers, we're talking about people making $60,000 a year. These are not highly paid folk. These are not people who are getting their fair share of the $10 billion. And what this exemption rate proposal does in the finance sector is that it seeks to cut incredibly important penalty rates, so overtime rates, weekend rates, standby rates, on-call rates, rates that finance workers rely on to be able to pay for their basic necessities in life. It cuts those and also can potentially make them work up to 12 hours of unpaid overtime a week. Now, our award sets out the bare minimum entitlements, and many finance workers are covered by collective agreements, but with the changing face of the finance sector, more and more workers are covered by the award and not covered by enterprise agreements. When we look at the exemption rate proposal in detail, one of the really shocking things, and I think our cases are probably quite similar to those of the ASU have seen, it doesn't take very much at all to see a worker have their pay fall below the rates in the award that they would currently get without that exemption rate. It only takes working, in the order of 2 days of on-call, working a couple of standby shifts, even perhaps having to have a work vehicle. That's all it would take for you to fall below what you would currently receive under the award. And we're talking amounts like $18,000 less pay over a year. So these are really significant losses for finance workers. It's particularly difficult this morning, I think, to be talking about this when we do have that CBA profit announcement, and the Finance Sector Union also currently has a case before the Federal Court in relation to very similar matters, with NAB failing to pay people the overtime that they were due because they weren't keeping appropriate time and wages records. So the amendment that Emmeline proposes to the regulations, we support that, and we think that is actually incredibly necessary. The finance sector is allergic to keeping proper time and wage records. One of the main reasons that they said they want these exemption rates is to avoid having to keep those attendance records. Their view is that employees don't want to do it. Our view is that, and our members' view is that they don't want to keep time records because it would prove the scale of their underpayment to their workers. So we have a real difficulty with any proposal that would allow finance employers to not have to record the time that their employees are working. We think that's an incredibly important step, both from a practical perspective to be able to reconcile that they are actually getting paid appropriately, but also for health and safety reasons to make sure that people aren't working excessive hours. We think that it is incredibly important that this bill is passed as quickly as possible because our exemption rates case in the finance sector is ongoing. I think the timetable is quite aggressive at this point, so the sooner these laws can come into force, the better for us, because we think they do provide incredibly important protections for finance workers. Thank you.
Thank you, Ms McPherson. And Ms Harrison, do you have a statement?
Thank you, Senator. Senators, the United Workers Union, as you're probably aware, represents 150,000 workers across 45 different industries, including cleaners, carers, educators, hospitality and logistics workers. Our members are from diverse backgrounds. They perform essential work that keeps Australia running. They feed, they care for us, they educate us, and they protect our communities every day. And without them, everything stops. They're often the lowest paid at a workplace, and they are heavily reliant on penalty rates. They work unsociable hours. We welcome the proposed amendments to the Fair Work Act as a positive step to ensuring that low-paid workers are fairly compensated for working unsociable hours. Our members regularly miss birthday parties, they miss family dinners, they miss significant life events to ensure that we keep functioning as a country. These sacrifices are not incidental. They are the cost of keeping services running during the nights, on weekends, on public holidays, and the bill rightly recognises that penalty rates are not a bonus, but are a necessary part of fair pay for work performed at times that disrupt family and personal life. The legislation follows years of employers' attempts to reduce penalty rates, including the 2017 Fair Work Commission decisions that cut Sunday penalty rates for hospitality workers. That decision reduced penalty rates for full-time and part-time employees from 175% to 150%, directly impacting the take-home pay of some of the lowest paid workers in Australia. It is a decision that disregarded the real-life consequences for workers who rely on weekend shifts to make ends meet. Since then, employers have continued to push for rolled-up rates and exemption clauses that undermine the award system. These proposals often result in workers being paid less than they would under the standard award conditions, and they shift the burden of proof onto workers to identify and challenge underpayments. Our members are already stretched thin. They should not have to become forensic accountants to ensure that they're paid correctly. And just on this, we have some lived experience in this space. The Hospitality Industry General Award continues to have multiple ways in which loaded rates or annualised salaries may be worked. And in fact, I think there's 3 different mechanisms that apply in the hospitality award. The original provisions in respect to annualised salaries, which applied to all workers except managers. So this includes your hospitality workers that are collecting glasses, so your lowest levels in the hospitality award. The original provisions in respect to annualised salary workers resulted in large-scale underpayments. A reconciliation provision which relied on workers calculating what they were owed routinely created underpayments of between $40,000 to $60,000 a year. So much so that in 2022, the Fair Work Commission proceedings put outer limits on these provisions. It required record keeping, it required 12-month reconciliation processes, a process to occur when an employee left. It also capped the extent to which overtime and the length of shifts would be covered, known as outer limits.
Harrison, I'm so sorry to interrupt. Would you mind just moving your microphone forward a bit? It's difficult to hear online. Thank you.
The point of these provisions was that these provisions routinely undermined the penalty rates that existed in awards. But just going back to the bill is a welcome response in relation to these ongoing threats. It strengthens the role of the modern awards and sends a clear message that the exploitation of low-paid workers through rolled-up rates or substituted rates won't be tolerated. The United Workers Union supports the reforms and will continue to advocate for stronger protections to reflect the value of our members' work and the sacrifices that they make every day.
Thank you very much, Ms Harrison. Is that the conclusion of opening statements? Yes.
No.
Oh, no, sorry, Ms Burnley. Just before you continue, we've just had a request to take photographs in the room. So if witnesses are okay with that, usual rules apply, no documents, no audience. Thank you. Ms Burnley.
Thank you, Senator. The SDA supports the legislation and the bill that's proposed before it, as we see it as a necessary and important step in protecting the penalty rates and overtime provisions and conditions that apply to retail, fast food and storage and service workers. Retail and fast food workers are in the lower paid section of the community on standards that have been tested by the Fair Work Commission, and penalties form an important and critical part of their salary, not only from the financial point of view, but also because they are doing these things at unsociable times. They're missing out on family events, sporting events, etc. They have to work on public holidays. They have to work late nights. They work rosters which most of us would look at and think they were abominable while we're sitting at home watching TV at night. They're there working, stacking the shelves, serving the customers. Supposedly there's a whole range of people wanting to come shopping at 10 p.m. at night in supermarkets, etc. So it is a critical fact that we need to have penalty rates protected for them. And our statement, our submission, should I say, did give some examples which were from some surveys. We didn't particularly ask them about penalty rates or what their wages were, but these were quotes that came back. So we had people saying things such as, the fact that the full-time rate in retail, the only reason I keep a roof over my head is due to my Sunday penalty rates. So it is a critically and vital component of the wages that people have. With respect to some of the other parts which are in the legislation, which goes to the issue of the rolled-up rates, the annualised salary, the exempt rate, whatever employers are deciding to call it or whatever the Commission decides to call that provisions, there isn't a restriction on the flexibility for employers to put those provisions into awards in the future. But what it does, it prevents that it doesn't cost the employee. It's not at the cost of the employee's wages and the conditions that they enjoy. So it's a protection to make sure that they are not disadvantaged by such arrangements. And currently the SDA does have has been defending an application in the Fair Work Commission currently where such a proposal has been put up that seeks to put in such an arrangement which would remove conditions and penalties and overtimes for supposedly high-flying managers in the retail award, but it is really aimed at the lower end of the managers, department managers and tradespeople. So they're not people who are in control of their rosters, supposedly. They are put on a roster, they get told what duties they need to do and they've got to do them. And the provisions which were proposed removed the protections regarding overtime, how many days a week they had to work, what shift length they were supposed to work. So if they decided to work a 12-hour shift, that was going to be fine. And there was not going to be record keeping of these things. Apparently it's too difficult to keep records. So we see that this legislation is very important to protect those arrangements, make sure those arrangements do not disadvantage workers. The legislation makes it clear that any arrangement must ensure that the worker cannot lose entitlements overall, such as penalties and overtime. Such a protection is welcome and will give workers greater confidence and assurance that even if such a proposal can come into effect in the future, it must have passed the logical test of not reducing their financial entitlements. Retail workers have seen and heard the current case, and we're extremely worried about the implications it could have, especially starting at a certain level in the award. It could then flow down to all the workers in the award, including, the person who is just a general shop assistant. There is that risk that's in there. So they're scared that they could, in the future, have their pay and conditions diminished, and many of them have experienced that when in 2017 the Sunday penalty rate and the public holiday rate was reduced in the GRIA and the fast food awards. So they've had to endure that setback. And as we put in our submission, there were some studies done after that decrease in the penalty rate occurred, because one of the claims which the Commission thought had some credibility was that there might have been a slight improvement in employment numbers with a penalty rate reduction. The three studies that were done showed that there was no such thing as an increase in employment. So people were financially worse off, which the Commission acknowledged that was going to occur, but they thought it would be outweighed by an increase in employment and in number of hours that people could work. That wasn't found to be true. So we just had members who were financially worse off. And we have dealt with underpayment cases with people who are on annualised salaries or exempt rates or what have you. The interesting thing is that we've never had a proper manager of a large department or supermarket, etc., has never come and been complaining about that they've been underpaid. It's always the department managers that come and have been underpaid by missing out on certain conditions, and they're the ones who don't have the control of when they're rostered. We support the proposal that the ASU have put up regarding the change to the regulation. In the GRIA case, it was a bit vague as to keeping records. The employers were a bit coy on what they were suggesting. They said, no, they don't need to keep records. These people all set their own rosters. They work their own hours. They know what they're doing. They can go home when they want to. Like to go tell the department managers that. They'd be very impressed with that answer. But it does seem that there is a loophole that if they're not keeping records, then they don't have to keep a record regarding the penalties and the overtimes if they're not paying them. So we think that would be an appropriate suggestion that could be put forward from this committee review. So just to conclude, the SDA supports this. Our members will appreciate the certainty that their penalty and overtime rates will be protected into the future with this proposed legislation.
Thank you, Ms Burnley. If that concludes opening statements, we'll now move to questions from senators, and I'm going to kick off from the chair. I wanted to come to you, Ms Dick and Ms Sumner, in the first instance. Could you talk us through what your job is? I know you mentioned you're at Officeworks and at Coles, I believe, is that? Yes. If you could talk us through what your job is and what the requirements are for you in terms of outside of hours work. Are you required to work late at night, on weekends? And what is the impact of the hours you work on your social life and your family? If you could just paint us a picture of that, please.
Sorry, hi, I'm Emily. I've been with Officeworks for, this is my 5th year. I work full-time and have full availability, so I can be required to work weekends and nights. I'm currently expecting my first baby, and thank you. So the working nights and weekends has an impact on not only my physical health with being quite tired because my work closes at 9 p.m. and I live half an hour away from my work, so having to drive at night, it's quite impactful on just being able to stay awake and travel back home safely from work at those times. The it impacts my work, because if I'm awake in the morning and working at night, I'm not working to the capabilities that I would during the day. I wouldn't be able to concentrate as hard as I could, and working on the weekends impacts my relationships with my partner, because my partner works full-time and he also does gigs on the weekends. So working those odd hours is kind of like ships sailing in the night. You don't get to have that time together. Sorry, what was the second part of the question?
Can you talk us through what your role is, and whether you're required to work on weekends or late at night, and talk us through the impact of if you are required to work these hours, on your personal wellbeing, on your family time, your hobbies. We want to hear about your personal experience.
Yes, I work. 99.9% of us that work in retail are required, if you want a job, to do either a late nights or weekends. I do Sundays at the moment. Losing my penalty rates from that would impact time with it already impacts time with my grandkids, but I can make it up because penalty rates means I can afford to spoil them a little bit. Without them, still have to give up my Sundays with them, and there's no reward, sort of. It would also make a difference for me to buy what I can afford compared to what I really like. It's the best way. Like if you're choosing apples, for instance, I know the ones I like, but you buy the cheaper ones because that's what would happen, because that's what you can afford to buy. The penalty rates means a lot. I've been with the company for over 30 years, and so I was already impacted by the first lot of cuts, and I can assure you there were no more. We had more staff 10 years ago than what we've got now. So all of that makes a difference. Public holidays, like I've done all of that to be able to get through as a single mum. So but how it would impact me now is time with my grandkids.
Thank
and
you.
Being able to do things with them. Thank you.
And Ms. Dick, what would the financial impact be for you and your family if you weren't to have access to penalty rates for this extra work that you do?
Definitely a major impact on savings. At the moment, I've currently moved in with my partner, so most of my savings have been impacted just from using it on remove lists. But then we're having to move again already, and trying to save for like Bubba and just prams and basic necessities, but also having to reevaluate just basic things like diet, and like Ruth said, just the choice between apples. You have to really think about every little thing that you spend your money on, which can impact your mental health quite a lot, because you're just constantly thinking about the cost of living, and being able to put aside money for the random surprise costs of bills or rego or petrol. It's difficult to just be able you'd have to think a lot about what you're spending your money on, and not really have much of a break.
Would you both say you financially rely on your penalty rates and your overtime rates?
Yeah, definitely.
Thank you very much. I'd like to put similar questions to Mr. Ward and Mr. Is it Tuchito? Is that Tuchito? Thank you for appearing today. Could you talk us through what your job is and what your patterns of work look like?
All right, well, good morning, Senators. So, my name's Noel Ward. I'm a school cleaner with Serco. So I work from 3:30 to 7:30. So they are very unusual hours to be working.
3:30 in the morning?
In the afternoon.
In the evening, yeah.
So, like security or retail, cleaning is a job. It's one of the threads that makes up the spider's web of society. It's our job. We ensure that diseases can't spread During COVID-19, when people had to stay home or couldn't go anywhere, we were there and we were ready. And without these jobs or people to take them, society would literally stop dead. Nothing would happen, everything would be. So lots of these jobs take place at regular unusual hours when people are heading home for dinner or going to sleep. So all these family milestones are missed as well. Even something as simple as being able to watch the news on TV, that TV show that you want to watch with your family. You can't do that because you're working unusual hours. So, not to mention, at my school we have trouble obtaining basic equipment, basic cleaning supplies because, the manager's inept and can't get the stuff in properly, all that stuff. But we have to rush here and there, making sure we get all the work done in a short period of time. We have to do it in the cold, we have to do it in the wind, rain, hail or shine. We have to be there, and again, we have to be ready. This is why penalty rates are a good thing, because it sends a message to the worker. Sorry you've been inconvenienced. Sorry that you have to stay back and work while everyone else is asleep. Sorry that you missed your child's birthday. So it's that extra amount to say, we're sorry, here you go, you work really hard. It's that extra amount of take-home pay that we can take home with us, that's ours, during a cost of living crisis. So this amendment to the Fair Work Act is a step in the right direction. Government that looks after the vanguard of society, which is the worker, is one that will be better off in the long term. Thank you very much.
Thank you very much, Mr. Ward. And Mr. Tuccido?
So my role, I work on a defence base, a defence establishment. I do security on a defence establishment, and my roster is night shifts and weekends, and day shifts on weekends and some days as well, 12-hour shifts. So night and our payroll is heavily dependent on penalties in order to make it worth it. In order to keep our bills paid and all that sort of stuff. And I can't tell you how many Christmases I've been at work or Easters I've worked, or when North Melbourne last won its grand final, I was working. So, and that's I know it's more serious than just missing a grand final. It's paying your mortgage. It's feeding your family.
If you weren't to have your penalty rates or your overtime rates, are there things you'd have to go without?
Yeah. Not myself personally now. I've been working for, you can tell I'm not the youngest person in this room. So possibly not much now, but I'm talking about when I was first starting out at the age of, in 2003, my son was diagnosed as being on the spectrum. The fact that I had days off through the week made it possible for me to get him the help he needed with early intervention. Normal job wouldn't have done that for me. His outcomes have been fantastic because of the intervention that he got. And at the age of 25, he's completed uni, and next year he's going to start a master's in his course. And without the penalty rates, there was no way we could afford to keep things moving. We wouldn't have been able to manage our finances. We wouldn't have been able to pay our loan. We wouldn't have been able to provide what most people call the necessities. So, sorry, it's not what I meant to do.
Appreciate you sharing that with us, Mr. Tuccido.
So these are the sorts of things. The impact it makes now, it's not as great. I've been working for a long time and we're okay financially. But there's not everyone in my boat. There's people that are just starting out. And an attack on penalty rates is an attack on their futures. and their ability to pay their loans and their ability to make ends meet. So that's why this legislation is so important. So that's all I've got to say.
Thank you. Thank you very much. Mr Ward, before I move on to another witness, did you have anything further you'd like to add on, what it would mean to you and your family if you had to go without penalty rates or without overtime?
Well, I think what it would mean is essentially, I consider myself to be in a very privileged position. I still live with my mother and my grandmother, God bless them. But that being said, it would impact my independence, my financial independence, my personal independence, every facet of my life that I take for granted. It would also affect me in the sense that, even things like apples, basic things like that, things that we need to survive as a species, like food and drink, become more difficult. And I also just wanted to piggyback off what you said, Vince, because I'm actually on the spectrum as well. And that really resonated with me about what you said. I'm really proud of you and I'm really proud of your son. So I just wanted to acknowledge that as well. You and your son are absolute legends, and that's all I have to say. Thank you.
Thank you, Mr Ward. I'm going to rotate the call now to the Deputy Chair. Then I'll be coming to Senator Pocock online and then Senator DeLager. So Senator Kovacic, you have the call.
Thank you, and thank you all for your evidence today. It's good to see such a full panel. It's usually the opposite, one or two people, so it's very nice to have you all here and your supporters in the audience as well. In any of your consultations with government in relation to these changes, was there any consideration or conversations around the economic impacts to small businesses of any of these changes? Did they sort of come up? Because I know a lot of the lens is on larger businesses, larger scale ones, and I note some of the evidence earlier in relation to errors by one of the major banks, who have hordes of, HR teams and lawyers who still get it wrong. So for a small business operator who wears all the many hats and works very, very hard, how do they manage this, and was that discussed or considered? I'm happy for anyone to answer it.
Just a general reflection on it. There's a significant number of exemptions in the Fair Work Act to accommodate the particular needs of small businesses. For example, in terms of redundancy or when unfair dismissal protections might apply. There's significant changes to the operative dates of, changes to the Fair Work Act in particular to support small business. So we, in any sort of discussions that we've had around this bill, didn't see the need to put in place yet more exemptions. In particular, this is a high-level principle.
So you didn't see the need? Was that what you said?
Yes.
Sorry, I just didn't hear.
Yeah, sorry, no, didn't see the need at all. This is also framed as a very high-level principle that would have universal application across the modern award system. On the question of small business, we'd also point out that those employees working for small business are particularly vulnerable. They are more vulnerable than employees in other businesses, and in fact they are even more vulnerable than the owners of many of those small businesses as well. And so those exemptions that I've outlined earlier do hit them particularly hard, and so we don't really see the case for any further exemptions.
Why do you consider them to be more vulnerable? I'm really interested in that.
They are more likely to be in part-time or casual work arrangements. They're more likely to be younger. They're more likely to earn less pay. They are more dependent on penalty rates. There's a lot of evidence on that. This bill also is not placing any additional requirements on a small business. It is simply effectively freezing the status quo around the rate of a penalty rate or an overtime rate. It's not an additional or new requirement as well. So for those reasons, we don't see the case there.
Interesting. On that basis, and I'm not quite sure whether an employee in a small business is more vulnerable than an employee in a large business, where you guys have noted the power imbalance in a large scale like a Coles or an Officeworks or a Woolies or a major bank versus a casual worker versus a small business that might have 3 or 4 workers, and they have actually a direct relationship with the person employing them. Do you think it's not risky to actually demand that such a change occur, and whether that could actually have an impact on that employment existing at all? Is there this potential risk that this becomes all too hard and it's just easier not to employ that person at all?
Well, the bill doesn't change any existing arrangements that are in place. All it does is mean that the workers at that business shouldn't be able to be paid less for the time that they give their employer that would normally attract penalty rates or overtime rates.
Well, there is the administrative burden of, recording all the different hours, doing all the different...
They have to do that at the moment, though.
In different ways, not in exactly the same way. There are some changes in relation to that, particularly if we think about the fact that we're at the highest level of small business insolvencies. I think we're at a 4-year high, 3 or 4 year high, and small businesses don't have the same capacity to absorb costs. Very much like employees don't have the capacity to absorb costs of rising cost of living, as was discussed here. I just want to be clear that what we're seeing here is actually based on evidence and understanding of what the impacts would be, as opposed to going, well, it doesn't matter, they should just do it anyway.
Can I just clarify? Just by way of clarification, if the reference that you're making is around the regulation that I talked about earlier, to be very, very clear, that is an obligation that already falls on employers, and all we are saying is that if employers would like to avail themselves of an exemption rate, they shouldn't then have looser arrangements around how the employee records that they keep. There's no additional obligations proposed on anyone through this legislation. It's merely that if employers would like to, all it is doing is making sure that workers' pay doesn't go backwards.
Though if there is an existing arrangement between an employee and an employer that falls outside of this in a small business, and then they wish to actually continue that, they are unable to do that unless they enter into an EBA. Is that correct?
I don't think this disturbs any existing arrangements.
You don't believe it does? So there's no change whatsoever?
I'm not...
Yeah, no, I'm asking the question, yeah.
Depends what you mean on an existing arrangement.
So let's just say, I'll give you an example. If you have an employee, as an example, that, let's just say, decides that they want a higher flat rate income, rather than having a penalty rate. This suits them for a number of reasons: greater ability to budget, improved borrowing capacity, steadier superannuation contributions, and perhaps reduced volatility in settling payments. So let's reference a single parent that's working. If they want to do that, the employer and the employee have negotiated that.
This doesn't disturb those arrangements.
So you're saying that will be able to continue?
Individual flexibility.
Yeah, as long as those arrangements do not have the effect of reducing the effective additional remuneration you get from that penalty rate. So the problem we have as a panel are proposals like that, but where the exemption rate is just too low, so workers are losing out effectively on their penalty rates that they're foregoing. So those arrangements can still take place, but that exemption rate needs to be high enough to properly compensate.
And how do you base that exemption rate? Not on their circumstance, or on whose circumstance are you basing that exemption rate on?
Well, the Commission would look at, the typical rostering arrangements.
Will it be based on that individual employee's circumstances or not?
If you're looking at award variation, they're looking across circumstances across the industry, so they would look at a particular employee, but they'd look at a range of potential rostering scenarios.
Correct. So even though that employee themselves might be better off, the current, or what you're proposing, might not be permitted. Is that what you're saying? If it doesn't apply across the board, I'm talking about an individual employee and their employer deciding they would like to do X because it suits both of them to do that. Will they be permitted to do that or not? Because currently, if there was an issue, the Commission could rule on it.
So, with respect, I think we might be at cross purposes. The exemption rates that we're talking about are award provisions that apply to a whole industry, which is what the business groups have made applications in relation to. So it's the business groups who have brought these applications to apply to an entire industry and not look at those individual circumstances and the individual rostering arrangements in each employer. What we are saying is that workers shouldn't be able to be worse off, and to do that you actually do need to do and scrutinise the hours that people are working and how much they're being paid for that. Separate to that, in the industrial relations system, workers and employers can enter into individual flexibility arrangements as long as workers aren't worse off overall, and that is very specific agreement between the worker and the employer, and that exists already, and that will not be disturbed in any way by this reform.
And you have no intention, or there's no intent of this reform disturbing the ability of an employer and an employee to make that decision themselves without the intervention of a union.
The bill is clear that those IFA arrangements stay in place.
Okay, I wanted to confirm that. My next question relates very much to that as well. And it was some of the evidence that was provided earlier around the research. I think it was, I've made a note of it here, the Markey and O'Brien study, I think, the one where it showed that there were 2 years' worth of research. I think on that piece of research, the Fair Work Commission asked for a 4-year window. Do we actually know whether that study that you guys relied on and analysed 2017 and 18 outcomes in the retail and hospitality sectors on the Sunday and public holiday pays, whether they can automatically be used to predict the outcomes for this? Like, are there significant variances between that and this now?
Senator, I'm just a bit confused because this what happened with that piece of study was to look at the effect of when penalty rates were reduced. And so they had been implemented when those studies were done. So the effect had already been passed through the industry at that time with those studies, which wasn't commissioned by the Fair Work Commission. It was the university took it upon themselves for the first study, and then the SDA and the ASU, not the ASU, United Workers and the ACTU funded for the further research to be done independently just to see what the effects were. So this legislation is about protecting and maintaining what the penalty rates are currently. So that study is about the effect, what happens with reduction in penalty rates.
But what's happening now, the employer applications now involve various different awards, right? And it's very different in the context, you know, with the matters that are before the Fair Work Commission to that. So I'm trying to understand what relevance that research has to what we're doing now.
Well, it shows that that the bill in its present form of protecting penalty rates will not have an effect of reducing employment, because what those studies showed that if penalty rates were reduced, there was no increase in employment, so there was no society benefit. So we're saying that if you're preserving penalty rates as they are today, that isn't going to affect employment continuing in these industries.
Okay. Do I have any more? Or am I done?
I was going to rotate, but
no,
we've got
fine.
plenty of time to come
Yeah,
back.
perfect. Come back.
Can I just clarify, though, on those questions, that the very purpose of this bill is to maintain the status quo. Is that not right? So it's not about changing existing arrangements. It's about preventing possible future changes to the status quo. That's correct? I just need you to say yes, because we don't have...
Yes.
Yes.
Everyone's nodding, but...
Otherwise the Hansard reports blank stares. Thank you very much. I'm going to pass the call to Senator Pocock, who's online. Senator Pocock, are you with us?
Yes, I am, Chair. Can you hear me okay?
Yes, we can. Please proceed. You've got just over 10 minutes and then I'll rotate the call again.
Yeah, no worries. I've got a few questions. I might get them done in that. Look, I'm really sorry I'm not there. I've got an event here in Adelaide. I have to be here and I would much prefer to be in the room. But thank you so much, everyone, for your evidence. It's very powerful and it's very clear that you have a unified view about the evidence suggesting that this amendment is necessary and you're looking for timely implementation. I have that clear message. I wanted to just begin my questions with going to the question of time and wages record keeping, which I think is interesting. I didn't expect this to come up, and I guess it's why we have people come and give evidence face to face. But I've heard, I think, from the SDA, the FSU and the ASU that you would like to ensure, possibly through amendment, that times and wages records need to be explicitly required even if an exemption rate applies. And that without it, just checking that I understood this correctly, that without it, uncapped hours and extended unpaid, extended periods of work that might affect health and safety and so on are not protected. Have I got that right?
Yes, you have. It's Emmeline Gask here, Senator. Thank you for that. Yeah, yes, you have, because one of the existing regulations only require time and wages records to be kept in circumstances where penalty and overtime rates might apply. And so one of the attractive features for businesses who do not want to keep those records any longer of an exemption rate is that it would no longer apply, whereas we say it absolutely should, to enable those arrangements to be scrutinised and checked that they're having the intended effect and workers aren't much worse off.
And Senator Pocock, it's Ben Moxon from the ACTU here. We also strongly support the ASU's suggested change to the regulations.
Thanks, Ben.
Senator Pocock, it's Larissa Harrison from the United Workers Union. I should say we also do support the amendments. I'd also add one of the trends that we noticed when the annualised salary provisions were brought into the Hospitality Industry Award before the 2022 amendments was that we actually saw massive changes in how employees were rostered. So we frequently had those on salary arrangements working in excess of 80 hours per week, and appreciating that even though there is the ability to refuse unreasonable overtime, that regularly doesn't get used by employees who are scared of losing hours, who potentially are in insecure work, and without the time and wage records that we did have the benefit of in the Hospitality Industry Award, we wouldn't have actually had the evidence to be able to show to the Fair Work Commission about the extent to which those annualised salary provisions were actually reducing employees' wages. So it was a very significant part of our ability to show how those provisions were actually operating, and that would be the concern that I would raise before this committee.
Thank you very much. That really clarifies and offers further evidence. I just wanted, Ben, if I could, to go to page 5 of your submission. About the middle of the page, you make the point, and I think we've heard evidence about it this morning as well, that even in relation to existing requirements, and I'm quoting you here, you say employers frequently do not comply with requirements to record working hours and carry out periodic reconciliations and so on. So have we got two problems here? One is the failure to have any requirement for keeping such records where there are exemption rates, and also a problem of a lack of enforcement of a requirement where it does exist to keep such records.
That's exactly right, Senator.
Okay. So we need to do two things then. Am I understanding this correct? And you all support it, both amend this bill to require the record keeping, but also we need to look at our enforcement regime.
Almost. We say the bill does not need amendment. It would be an amendment to the Fair Work Regulations 3.34, simply to add the requirement to record properly where there's substitution rates being used. On the enforcement question, that's obviously a much bigger question where there's a wide range of reforms to deal with widespread systematic wage theft across the labour force. And those key reforms, many of which have just come into effect earlier this year, I think will be reviewed later this year, where we'll be looking closely at how effective they've really been.
And if I can just ask you, in relation to enforcement, we of course in the Parliament have the Fair Work Ombudsman come before us. We will later this year. Is this issue really one for the Ombudsman, or which enforcement levers need more attention in your view?
Senator, I maybe we can take that on notice, but I think that the point is most the point goes to the fact that there ought to be an obligation to keep these records, and that there is a real risk that if those records are not kept, that is where wage theft flourishes. And that's borne out by, the most heinous examples of wage theft that we've seen. So I think that just underscores the importance of having those obligations, as the obligation itself is what gives the worker the course of action to review the circumstances if there's wage theft occurring and enforce their entitlements.
Great. Okay, thank you.
Sorry, Senator, this is Nicole McPherson from the Finance Sector Union. We currently have a fairly substantial problem with annualised salaries in our award and employers not doing the reconciliations required under those existing annualised salary arrangements, and we deal with that as an enforcement issue. The challenge that we would have with this exemption rate case, if it were to be successful in the BFI without these laws, is that there would be a really significant risk that if the banks can't comply with the existing levels of regulation on annualised salaries, if they no longer have any requirement to keep any kind of records about how many hours people are working, it would be completely impossible for us to do that enforcement work at all. So while there is an enforcement issue at the moment, especially with annualised salaries for us, with the current drafting, it would not be possible to do that kind of reconciliation with these amendments.
Okay, right. Thanks for that clarification, Nicole. I appreciate that. And very useful evidence. Can I go to a second issue, and that's the issue of employment? There is evidence, I think it's in the ASU submission, and it's been referred to already, about how previous cuts to penalty rates did not. There's no evidence that they've increased employment. But I wanted to go to, which is a real concern, that's an important part of the argument. But is it not also the case, listening to delegates and listening to workers here this morning, that there will be a negative effect on labour supply if these cuts to penalty rates occur? When I look at the evidence in the ASU submission, worker after worker saying, I wouldn't do this work unless I was paid penalties, I'd withdraw from the labour market, I couldn't keep doing this job. In a circumstance of a tight labour market, 4.3% unemployment right now, there is a real danger, is there not, and I'd like your comments on this, of a tightening of labour supply, a decline in labour supply, which would make running a lot of these businesses, including small businesses, even more difficult.
Senator, that's exactly right, and this is it's Ben from the ACTU again, and this was an issue that was aired in significant detail in the recent annual wage review proceedings, where retail and hospitality employers, one of their top complaints is the inability to attract and retain staff. And what it comes down to, and this is evidence that Jobs and Skills Australia showed, is that they face what they call in the trade a retention gap. What that means in layperson's terms is these workers are not being paid well enough or treated well enough, and they're typically getting jobs in other sectors. So the idea that you'd reduce pay and conditions in retail and hospitality as a way of attracting more staff just does not add up whatsoever. The Fair Work Commission went through these arguments and really accepted that position in its recent decision.
Great, thanks, Ben. Chair, do I have time for a couple more, or do you want to swap?
Would you just have a couple more, Senator Pocock, or have you got like another block's worth?
I've just got two more technical questions, probably for the ACTU.
Yep.
Please place them. So, yeah, Professor Andrew Stewart's submission raises questions about what qualifies as a rate reduction, and he observed that while the rate of a penalty could be reduced, for example, from 150 to 125%, the circumstances in which they could be applied could also be changed. For example, extending the circumstances in which ordinary hours can be worked on a Saturday without a penalty applying. This would result in a reduction in take-home pay for a worker without explicitly reducing the rate paid. In your view, Ben, if this bill, or others, if this bill is passed, would it still be possible for employers to change the scope or circumstances under which penalty and overtime rates apply?
Thanks, Senator. We think Professor Stewart's taking a fairly literal reading of the bill, but our reading of it would be that subsection 1A, small a, just refers to the rate of a penalty rate or an overtime rate. It doesn't refer to, the circumstances by which it might apply in terms of, issues around, spread of hours. However, subsection small b talks about a substitution rate that has the effect of reducing the additional remuneration you get from a penalty rate. So we can see an argument where an employer bowls up an exemption rate clause application to the Commission that is really trying to change the span of hours or when these things come into effect. We think there's an arguable case that the unions could mount there to say, actually, no, this is just another way of trying to reduce that additional remuneration. So the core principle, no, we wouldn't agree with Professor Stewart, but we think in an exemption rate case, it's an argument that could be run. We should say that this amendment is at the high level of a principle, and in all these cases, parties to future proceedings in the commissions or the courts will test the arguments, and there'll be clarity from the Commission and the courts about exactly how they're going to apply them, and that's the normal practice of things.
Okay. Second technical issue. I understand that on the 31st of July, the government passed an amendment to the bill in the lower house that sought to clarify that, quote, nothing in subsection 1 requires the Fair Work Commission to exercise its powers under this part to make, vary or revoke modern awards, end of quote. However, some stakeholders still have some concerns about this. Is it your understanding that this bill would not require the Fair Work Commission to review penalty and overtime rates in an award if that's not the primary focus of the review?
That's exactly right. The amendment just clarifies that the Commission should look at the application in front of it and that it shouldn't go off on a broader exercise to look at all terms in the award or across the modern award system. So it's really just focusing the task of the Commission in applying this principle to the application that parties have put in front of it, and we're entirely comfortable with that. If a union wanted a particular loaded rate exemption rate to be examined, it would make an application targeted at that.
Mm-hmm. Great. Well, thanks so much for all of your answers and your evidence. Thanks, Chair.
Thank you very much, Senator Pocock. Passing the call to Senator De Lager.
Thanks, Chair, and thanks very much, everyone, for your evidence so far, and especially to the members and workers coming in today. I know it's can be a little bit daunting fronting up in a committee like this, but you all have done fantastic so far. My first question is to Ms. Gasky from the ASU. Can you tell us about, like I was reading through your submission, and about some of the vulnerable workers in, say, the call centre industries? I've worked in call centre industries in the past, like government and public, I'm just curious as to some examples of how penalty rates are important to your members and to vulnerable workers in the call centre industry.
Yeah, excellent. Thank you. I mean, they're absolutely essential. So the work is, it is hard and repetitive work, and it is done in difficult environments, and it is done, particularly for workers who are, it's often done late at night, and being available in those late night call centres or early in the morning for companies that want to provide service outside of 9 to 5 to their customers. And it is hard, and it is stressful, and they deserve every red penny that they earn for doing that work and dealing with customers' complaints and concerns on the other end of the phone, but also that they lose so many opportunities to for recreation and rest and time with their families and impact on their well-being, that it's extraordinary that those workers on reasonably low salaries could be considered to be paid so highly that they should have to forego overtime rates and work up to 50 hours a week with no paid overtime, or work on a Saturday, for no extra money, just because they are earning in 65 grand a year.
Yeah, absolutely. And I might also put the same question to Ms. Harrison as well, to your members. We've heard for a couple of really fantastic examples, but there are other examples of workers who might be more vulnerable in your coverage who rely on their penalty rates.
Look, I think it might actually be, almost most of our membership, but look, as I indicated, we have, as you've heard from Mr. Ward, who's a cleaner, we cover cleaners in a whole range of different walks of sort of in different industries. So cleaners that are cleaning the shopping centres after people leave at night, cleaners that are cleaning those your office buildings, they are working outside of ordinary hours. They're working late nights, they're working early mornings. We also have obviously hospitality workers. They are working in pubs, in clubs, in food outlets, and we then have carers. We have those that are caring for aged care for your elderly grandparents and parents who are in aged care homes, who are providing 24/7 care. We have disability carers that are caring for them, and these are a lot of industries where we already have labour shortages. So we have shortages of workers. They are already some of the lowest paid in Australia. They're already missing weekends, and without penalty rates, the desirability to go to work and to work those weekends, to work those after hours, it reduces. And so that is the nature of where penalty rates, I think, are probably have the most impact.
And Mr. Ward, I was just going to ask you, when being a delegate representing other members as well, when you guys talk in your workplace about, if you're in the lunchroom or if you're like working around the office, when you're talking and you hear, penalty rates are at risk and, or it's going to give greater flexibility. Do you as workers and do your members think this is going to be great to have greater flexibility, or your penalty rates? What do people actually say in the workplace?
Well, the few times we do get to talk, because our contact is fleeting, and one of our workers who's a really hard worker, there's a bit of a language barrier there, sadly, and I'm actually the only member of the union at that workplace. But I imagine that if I were to speak to him or my other colleague, I would imagine they'd be very happy, because both of them have kids they have to look after, and so I think if they knew about this, I think they'd be happy, because I know there's many people who are too scared to speak out for whatever reason, and most of these jobs as well, there's lots of migrants that work these jobs and they have to send money home to their family, and if it wasn't for the fact that they're doing that, well then they can't, subsist. So I think, to answer your question, Senator, the few times we get together, I think they'd be very happy that this is putting extra food on the table, extra money to take home, and they deserve every cent of it.
Thanks, and I might ask, sorry, I can't read your name from back here, my vision is shot. So I might ask Miss Dick, what do your fellow workers say when you're talking about, your penalty rates are at risk, or, if you don't get penalty rates, there's greater flexibility. How do you guys see it in the workplace when you're chatting?
When I told them that it was at risk, they were scared. I've got this one team member who he used to work nights a lot. He's been with the business for 10, 15 years. He's a full-time worker. He would constantly do nights. He is lucky to own his own property, and so he, on top of paying mortgage and his strata fees, when my work changed his hours so that they wouldn't have to pay his penalty, he's only left with $100 a fortnight to be able to afford food, and he struggles every week, especially with our RDOs as well. He's got one short week, or one short payment a fortnight. So they were definitely scared, with the opportunities to pick up those extra night shifts. They were very worried, but they're happy that we're bringing this to attention.
So even, sorry, just clarifying, you said even with your penalty rates and you're paying mortgage and strata and everything, $100 left in the pay just for your food, essentially, like.
So that was after they
Yeah.
moved his hours
Yeah.
so that he wasn't getting those penalty rates
Yeah, wow.
anymore.
Yes,
Yeah,
right, okay.
he's left with the 100. But before, when he was doing those night hours, he took that into account when he, like ages ago, when he did sign up to have his house and things like that. But now, because circumstances have changed, he's struggling. So, yeah.
Thank you. Thanks very much. And Mr. Moxham, I might just ask from the ACTU, you know, we're hearing a lot of stuff from workers and everything today. Can you tell us about why this is really necessary, you know, this legislation, and why the existing protections don't cut it?
Yeah. Thank you, Senator Delega. I just want to add some numbers to the stories that you've just heard from Ruth, Emily, Noah and Vince, and this is an analysis we did after filing the submissions on Friday. So we sort of asked how many people rely on penalty rates, and if you look at the award-reliant workforce, there's 2.6 million workers that directly rely on award. There's millions more that rely on the award as their sort of bargaining safety net for setting their own terms and conditions through a collective agreement or an individual arrangement. But if we just look at those 2.6 million workers, nearly 1.2 million of them would work on a weekend. Nearly 900,000 of them work night shifts. And these are overlapping categories, yeah? You can work both night shifts and weekends. 500,000 of them do shift work, and 660,000 of them work overtime. So think of the 4 stories you've heard today and multiply that by millions. And then what do we know about award-reliant workforce? You know, they're younger, they're female, more likely to be in part-time or casual work. They're also 6 times more likely to be low-paid than the workforce at large. And what do I mean by low-paid? It means you're earning less than 2/3 of the median wage. Recent research commissioned by the Fair Work Commission says if you're earning less than that, you are under serious financial stress. You cannot afford to live in most major capital cities in this country. You're having to cut corners on food. So that's about 1 in 3 workers reliant on a modern award. Penalty rates is the difference between that level of extreme stress and not facing that. And we're not talking about, you know, people doing a few shifts while they're at university, living with mum and dad. We're talking about a whole lot of, you know, parents or people living alone that are award reliant that are in the lower ends of the household income distribution. Why do we say this is necessary? I think we've covered it in some detail, but from a technical aspect, the modern award objective contains a whole number of elements. One of those elements is the need to provide penalty rates and overtime. The Commission goes through a balancing exercise across those elements when it comes up with an award or varies the award. We say that penalty rates are too important to be subject to a balancing exercise, that they should be an absolute minimum core entitlement that is rock solid. And the 2017 Sunday penalty rates case, as everyone here has spoken about, is a great example, a cautionary tale of why that balancing exercise doesn't work. It was very much a trade-off in the eyes of the Commission that you'd lower Sunday penalty rates and it would create jobs. That did not happen in practice. All the research commissioned about it, as Sue-Ann has gone through, showed that the job creation did not eventuate. Instead, you had the sort of hardships that, in particular, I know Ruth spoke about. So we say it's too important for that balancing exercise. It actually needs to be a really strong, clear safeguard in place around the level of a penalty rate.
Thank you. And Ms McPherson, I was going to just follow up from your opening statement about the workers in the banking and insurance sector, and a lot of them being on the Clark's Award. Was it that you said? Sorry, or the
Banking Finance.
Sorry, Banking Finance Award. With these awards, and how many workers on the awards are relying on penalty rates, or like in a broad sense, and how would they feel like with, you know, losing their penalty rates when the employers are, like you said, the CBA making $10 billion in profits? How does it feel like for your members, and what are they saying to you?
Yeah, look, every time the banks make a profit announcement, the first thing that happens is members contact us and say, wow, or the annual report comes out, wow, Matt Common, the CBA CEO, made $10 million this year. It's a lot of money. And we say, yes, it is an enormous amount of money. Let's work out how many multiples of your pay that is. And it's always some disgracefully high number. I think when, as I said in my opening remarks, when people think about finance workers, they tend to think of the guy in the Maserati. What they don't think about is when their house floods or they, hit a kangaroo at 4 a.m. and they need to call a finance worker to get some help with an insurance claim. There's a finance worker sitting at the end of the phone to take their call, to help them through the stress of having just smashed their car and to put that claim through. And these are the lowest paid people in the finance sector, and these are the people that are most reliant on those penalty rates. When you find out that you've been scammed, you check your bank balance and there's nothing in there. That's also the situation where you need to call a finance worker, again, one of the lowest paid workers in the sector. And these are people that work on 24-hour shifts, they work on rotating rosters. These are the people that are the most reliant on the penalty rates because they receive them as a matter of course in their roles. They're also the lowest paid workers in the finance sector. And what they tell us is that without those penalty rates, they would simply not be able to afford to do those essential jobs that our community needs when they need to access the finance sector. That it would be incredibly difficult for the finance sector to be able to attract and retain people into those roles. We are already seeing the impact of this with a number of the insurers and the banks offshoring these critical roles. So that's the very pointy end of this issue in the Australian finance sector, that people won't do the jobs. The banks say that and the insurers say that there's a skill shortage, and then they go offshore. But the problem is we do have a quality finance sector here. We just need to pay them properly and treat them decently, and then we will have the finance sector that our community requires.
And just to clarify, earlier on, you said it was up to some of the worst cases if they were to lose their penalty rates, and being some of the lowest paid workers, it was up to $18,000?
That's right. That's for an award-covered worker on level 3.
Wow. Thanks, Chair.
Thank you, Senator Delager. I'm going to put a few more questions to Ms Burnley. For the workers you represent, can you just tell us a bit more about what losing penalty rates for overtime would mean to them? What are your members telling you about that, their fears or their concerns?
So they are fearful of losing them. They see that every time there's a mention of some sort of productivity measure or trying to increase something, their penalty rates always seem to get into that mix that, if you cut penalty rates, that'll increase productivity somehow magically, which is mixing up between outputs and costs in those measures. So they are very scared. They are at the lower end of the pay scales. They're below that 2/3 median's average weekly wage. They are predominantly women. I think it's 65% of our membership is women, and the retail industry is predominated by women still, and fast food is with young people. They are part-time, so they do a big juggle with their work and care responsibilities if they've got a family or they're caring for older people, younger people, siblings, etc., which falls on their shoulders to be able to accommodate. And part of their juggling act is making sure they've got enough money. So they do either choose to work sometimes in the penalty times, or they're required to be working at the penalty times, and they need that financial reward so that they can try and keep the juggling act going through their life, and that means that they can maintain some dignity in how they are able to finance their lifestyle, which isn't the luxury lifestyle. It is it's covering the necessities. And as our members say, it might be the occasional dinner they'll go out for. It's the big treat. Every 6 months they'll go out for a dinner somewhere that they've saved up for. They're not going off on the overseas trips. They might be going down for the camping trip at Wilson Prom. So financially, they do need the penalty rates, and they get threatened. So this bill will give them certainty that they're not going to continually be faced with a threat to their penalty rates, which they've been enduring for a long time now.
And say the workers at Coles and Woolworths and Officeworks didn't make themselves available to work on weekends and the evenings. They actually took that time back for their families and their personal well-being and their health. What would the impact be on those businesses?
They'd struggle to get workers, although they'd probably just go on, I think at the moment, even though the market is strong regarding, it's tight regarding the labour market, we know that there's always somebody who's going to be prepared possibly to come and work. What's the quality of that person that's coming into work? Because it would reduce the people who are the good workers who have been there a long time. They would think twice about whether they are prepared to go and work in the retail, which at the moment is quite unpleasant at times with the attacks which are occurring in stores and the abuse that retail workers are having to face every day when they're getting abused. So it would mean that they would probably not make themselves available because they
I mean, I guess my question is, would Officeworks be able to open if workers didn't turn up on a weekend? Would they be able to open on Saturday? These businesses need their workers.
They
to
do need
these
their
hours.
workers, so if nobody's volunteering to work, however, most of their contracts are that they're required to work, so that they'd get, if they're requiring and forcing people to work at the times and there is no penalty rate, they're probably going to have a very workforce that's not very happy and probably isn't going to be performing well, and they're probably going to be leaving the industry and finding a job somewhere else.
Well, they may not have a thriving business either. Ms Harrison, can I ask you again about what your members are telling you at a personal level about the impact of losing their penalty rates or overtime would be? What's been shared with you that you can share with the committee?
Certainly. Look, our members are already struggling to make costs meet. The cost of living is increasing. Their wages are not keeping up with those costs for them. And they're already struggling to pay their mortgages, to pay their grocery bills and to pay for the basic needs of their families. And the concern is that without penalty rates, they just don't know how they're going to survive. And that is, and I think, and you can appreciate the difficulty of, it's not as simple as saying, well, they're going to find other work. We're talking about workers that have worked in these industries for their careers, that they enjoy it in aged care, in working as hospital orderlies, as working working as a disability carer. They genuinely care about their clients. They care about the residents they're looking after, but it gets to a point where they can't afford. If they can't afford to live, they might have to actually move out of those sectors, and we know how. And so their budgets are so tight that the possibility of penalty rates being reduced is something that they factor into every single day decision that they make.
Thank you very much. I'm going to pass the call to Senator Kovacic, and then I think if we've got time, Senator Pocock's got a couple of questions as well.
Thank you. I'm not embarrassed to say I'm scratching my head a little bit. I'm confused. In the ACTU submission, it talks about the bill being a simple amendment, but there seems to be quite a bit of confusion about a couple of little things, including a question from Senator Pocock about an interpretation from someone that I think Mr Moxham you referenced as a fairly literal reading, and then you went as our reading says, and then I'm trying to work out, well, what are the actual impacts of this? Like, how are penalty rates as they stand now, with the agreements as they are, and with the work of the Fair Work Commission as it is, how are they actually at risk?
It is completely open to the Fair Work Commission at the moment to accept those submissions by employers to introduce exemption rates that would leave tens, if not hundreds of thousands of workers worse off.
Have the Fair Work Commission conducted themselves in a manner that has left any workers worse off?
It's hypothetically possible for
it's
them.
So they haven't done anything wrong to this. So at this point, the Fair Work Commission...
They haven't handed down their decisions.
Right.
Which is why we think this bill should be passed promptly.
Okay, so nothing to date has occurred. There's no real or clear pathway or any sort of push from employers or employer groups to cut penalty rates, but purely to have discussions with individual employees whether they would actually like to have their own arrangements. That's the risk. So the Fair Work Commission actually ruling that an individual employee could negotiate with their employer. Is that the problem? Because I'm trying to understand, and just so I'm clear, because the evidence has been around why penalty rates are important and how they help feed people and all the rest, and that is all legitimate. I don't have an issue with that. I'm trying to understand where the narrative or the evidence, more importantly, is coming from that penalty rates are actually at risk.
I would, with respect, I think you said that the employers are having discussions. They've actually put applications to the Fair Work Commission which are clear proposals, which on the analysis of the unions and the members here shows that it would dramatically cut their pay It is completely open to the Fair Work Commission to agree to those proposals. If we look at the decision of the Commission in the Sunday penalty rates case, that's exactly what happened. That's why we are concerned and alarmed about it and welcome this bill and want it passed promptly. It's also open, as I think many of us said, for employers and employees to negotiate a whole range of flexible work arrangements. There's a number of avenues in the Fair Work Act. This bill disturbs none of them.
Can I just add to that? In terms of our members, the applications that the Australian Industry Group, Australian Business Industrial and the New South Wales Business Chamber have put their applications into the Fair Work Commission and said this is how the award should be amended, would have the impact of cutting our members' pay by $15,000 a year. In that example,
but that's on a worst case scenario. That's not an average scenario, correct? That was my reading on it.
No, that's an ordinary worker who's only working 6 hours of overtime a week. Under the proposals that are actually before the Commission, we could be much more alarmist, and by the Commission,
I would be surprised.
Watch me. But I think, but under those proposals, workers could work up to 12 hours unpaid, extra overtime. So this was a real example of a worker who's just doing 6 hours of overtime a week and the impact financially on her. So the risk is real and present, and the employers are presently pushing for this to happen and putting on evidence in the Commission arguing for this.
I'm genuinely trying to understand, and that's the purpose.
So that's the risk, and this is about what should the Commission consider in making decisions on these cases.
Well, then in that case, because I know time is running out, I have two final questions to that, and then...
Sorry, I think Ms Harrison was seeking to
answer,
yeah. You're right.
And look, Senator, can I also just add, as the ASU's indicated, and we don't have a direct interest in the case that's before the Fair Work Commission. I understand those wages are averages, but we've also seen situations in which when there are sort of annualised salaries or whatever you want to call them in awards, is that the actual hours and patterns of work change, which is that employers make business decisions, which is to roster people on in the way that is cheapest and makes the most profit for them. And what we saw in the hospitality industry was hours of work that were in excess of 60 hours per week, up to 80 hours per week, 12-hour shifts frequently done plus extra overtime. And so even if it was the worst case scenario, which I understand it is not, also understanding that business decisions will be made as to what is the cheapest way in which labour can be provided, and salary arrangements give that opportunity to actually go well above the 38-hour week.
Yeah, and again, I think they may be worst case scenarios. I don't think all employers act in bad faith. And I think that's probably the suggestion. But my question, Ms Gasky, is would you then support a legislated review clause, say after 2 years, to ensure, that compels the department and the Fair Work Commission to report on impacts, particularly relating to, award simplicity, flexibility, compliance and small business viability? Like, is there any reason that we can't go, okay, let's actually check that this works? Let's have a mechanism that says, let's test it.
I just want to address what you did say a moment ago about how not all employers are doing, the worst case scenario.
They're not all acting in bad faith.
I want to be really clear, though, that under their proposed amendments, this is exactly what they are proposing to do. Now, whether you want to characterise that as acting in bad faith or not, that's a matter for you, but they are proposing to put in place the arrangements.
It's not a matter for me, it's an actual fact. There are many employers in this country, of which I was one, that actually care about outcomes for their employees.
Absolutely.
Want to ensure that they have a good and safe workplace and want to have good conditions for them, in the same way that there are many, many excellent and wonderful employees in this country who work really hard and go above and beyond. And I don't think that's a battle of good versus evil. No. It's about ensuring that we actually have strong, viable employers, particularly small businesses that are regularly crushed by this form of legislation, particularly when it's unnecessary. And I'm trying to understand the purpose of this and the necessity of it, and that will lead me into, the discussion around the employees at Coles, Miss Burnley, around, this legislation doesn't actually change anything for your workers. You know, their enterprise agreements currently have, you know, the Saturday and Sunday rates that I think are 25% and 50%, and nothing will change. And the complaints,
it gives them a security going forward, which they don't have at the moment. They have been through at least 13 years of uncertainty regarding their penalty rates. It's been under attack ever since the GRIA was formed. As soon as it was formed in 2008, the employers were out complaining about the penalty rates, saying that we were backwards, we weren't an appropriate award for a 24-hour, 7-day-a-week industry.
But
however, our award did move, and it is a 24-hour, 7-day-a-week award with appropriate penalties. So our workers have been constantly under review as to what their penalty rates should be, which resulted in 2017 that they were cut. So it could happen in the future again if this legislation isn't in place.
But my confusion is the current legislation doesn't even address the current concerns that your workers have.
The legislation that is proposed does address the concerns in that the penalty rates and overtime rates would
But not in
be
the current
reduced.
pay rate. Like, I find it unusual as to what is going, and I can't help feeling like there's a little bit of a scare campaign running about penalty rates. I find it quite.
Could I address one question? The question of employers. I think I actually wholeheartedly agree with you. I don't think there is a long line of employers out there begging to cut the penalty rates of their employees. Yeah. And I would urge them, and I have actually contacted many of them and urged them to raise their voices in this debate, because the AIG and the ABI and Business New South Wales are, in their name, making these applications to make these changes to the awards. And I think that there is a very small cohort of very vocal people who are pushing for this, whereas I think there are plenty of people who would not want to cut the entitlements of their employees or make them work 12 hours for free extra every week. And we are strongly encouraging them to raise their voices and say, no, of course we don't need these applications. And for them, this law should mean nothing for them, because all it means is that the status quo remains, and there's no additional obligations on them, and they can keep going and having the really productive relationships they're having with their workers in their workplace every day.
And if I could just finish on this, then why don't we just allow the Fair Work Commission to actually do their job? Because I'd like to understand, perhaps Mr Moxham, if you can answer this, how you propose that this will actually change the way the Fair Work Commission operates. Is it basically saying, we don't trust you, Fair Work Commission, to look after workers, so we want to legislate this because we believe that, the big, mean, nasty employers are going to come to you and seek penalty rate cuts? Is that what you're actually saying? Are we carving out the right of the Fair Work Commission to do their job in this space?
It's not a question of trust, it's a question of an essentially needed safeguard around the rate of penalty rates and overtime rates.
And the Fair Work Commission is not capable of applying that appropriate safeguard?
It's the role of the Parliament to set the objectives that guide the work of the Fair Work Commission, and from time to time it has updated those objectives. For example, the promotion of job security in 2022, the realisation of gender equality in 2022, community attitudes have changed. That's resulted in a range of really great outcomes in workplaces across Australia.
And you don't think that takes away the flexibility for the employer and the employee then? Because we're actually legislating that out potentially.
So this is a clear safeguard to guide the discretion of the Commission. That flexibility, which I think we've answered many times, for employers and employees to sit down and discuss and come up with new working arrangements, exists in a range of channels. I'll go through them again. The employers can still make applications for exemption rates as long as those rates are high enough not to deny people their penalty rates.
But that's for everyone. That's any employee test, not an individual employee.
Well, that's around changing an award. But for an individual employee, they can go through an individual flexibility arrangement, which could achieve this. I should say this has a better off overall safeguard within it, which the modern award objective currently doesn't have, which is what this bill would correct. They can sit down and collectively bargain with their workforce and the union to achieve these sort of trade-offs.
Let's assume it's a small business.
Again, there's a better off overall test in place to prevent workers from going backwards. Again, that's what this bill would do to the modern award objectives. There's also individual flexible work requests that employers and employers can sit down and have been using in record numbers since the laws were improved a couple of years ago. So many, many channels.
Yeah. I guess my concern is around, taking the option from or taking this away from the Fair Work Commission, but I acknowledge we perhaps differ on that. Thank you, Chair.
Thanks, Senator Kovacic. Senator Pocock, you've got a couple of minutes if you want to put a few questions.
Thank you. I just wonder if you could comment, probably the ASU, others may have comments about what would happen if this bill was not passed for gender equity in the labour market, especially as it relates to pay, but also to the possibility that if it's not passed, there could be extended hours of work that are not adequately recorded, and long hours of work are toxic for women or carers' employment. So both the wages impact and the employment impact for women and carers.
Yes, thank you, Senator Pocock. We've been really pleased with the closing of the gender pay gap that we've seen over the last few years, and it's as small as it's ever been, and we've got more work to do, and we look forward to working with government and others on that. But the necessary impact of cuts to penalty rates would be to send the gender pay gap, to widen it again, to send it back in the wrong direction, because it is overwhelmingly women who rely on these pay rates. And if they got a pay cut, then obviously millions of women getting a pay cut is going to have a really negative impact on the gender pay gap, and that would be a really devastating thing to see after all of the progress we've made. On your second point, I think it's a really good point to make around how where there are workers who are not presently undertaking overtime or working on weekends could be negatively impacted by the changes to by the exemption rates cases that are presently on foot. And in particular, that would be any worker who is currently working an ordinary sort of 9-to-5 arrangement. If the exemption rates, as they're presently put forward by the AIG, were successful, those workers could then be forced to work additional overtime and work on weekends and work outside their ordinary span of hours for the same pay as they're getting now. So it would absolutely have an impact on the workplace arrangements that are in place for workers, even if they're not currently getting the benefit of penalty rates. And that would, of course, have an impact on those people who are trying to manage work and care and family arrangements, and changing their patterns of work would have a huge impact on them.
Thanks. Thanks so much for that answer. Thanks, Chair.
Thank you, and thank you, Ms Gasky. That concludes our panel today. I want to thank all of our witnesses for coming and sharing with us, for taking the time to make submissions to our inquiry, and especially to those workers who joined us today. Thank you for taking the time out of your work and your schedules to present to our committee. We really value having lived experience members on this committee. I don't believe you took questions on notice, but if I missed one, they're due back by the 15th of August. But otherwise, you're dismissed, and thank you again. The committee will now suspend, returning at 11 o'clock. Okay, I declare that the committee will now resume, and I'd like to welcome Professor Chris F. Wright. I understand that information on parliamentary privilege has been given to you, Professor. For the Hansard record, could I please ask you to state your full name and the capacity in which you're appearing today?
Chris Wright. I'm a Professor of Work and Labour Market Policy at the University of Sydney, but I'm appearing in a personal capacity.
Great, wonderful. I'd like to invite you to make a short opening statement if you wish to do so, and then at the conclusion of your statement, we'll have questions from senators.
Thank you, Senator, for the introduction, and thank you for the opportunity to appear before this Senate committee inquiry into the Fair Work legislation amendments protecting penalty and overtime rates bill. So this opening statement covers the key points in my written submission and provides additional context for those points. Extensive international research has established that the most effective labour market policies are those that balance businesses' need for efficiency with workers' need for fairness. Policies that strike this balance between efficiency and fairness typically improve worker satisfaction and encourage businesses to compete through high-road strategies based on productivity and innovation, rather than low-road strategies based on undercutting competitors' labour costs. Over the past few decades, there has been a worldwide shift in labour market policies away from arrangements broadly focused on balancing the needs and interests of employers and workers towards arrangements that have given greater priority to employer interests. This trend has been most pronounced in the so-called liberal market economies like the United States and the United Kingdom, but has also been evident elsewhere, including in Australia. These developments have contributed to increased income inequality, which in turn has contributed to diminished social cohesion and declining confidence in democracy. While income inequality has increased in Australia over that period, it remains lower than in the United States and the United Kingdom. Australia's award system of industry and occupational minimum standards is a key reason for this. Penalty rates and overtime rates of pay, compensating employees for work performed during unsociable hours, are integral protections within the award system. They're especially important for employees who rely on awards for their pay, who are disproportionately low paid, female, young and experiencing financial stress. Penalty rates can make it more challenging for employers to calculate their employees' pay rates. Rolled up pay rates or pay arrangements where employees receive a higher overall pay in exchange for penalty and overtime rates can be a legitimate solution to this complexity. However, the misuse of these arrangements by some employers that have eroded workers' pay highlights the risks of these arrangements. The award system, the role of which is to serve as a safety net to protect the lowest paid, is not the place to take these risks. The collective bargaining system, with its inbuilt protections, provides a more appropriate venue for rolled-up pay arrangements to be negotiated. Allowing employers to propose higher base pay in exchange for removing award penalty rates could be presented to employees on a take-it-or-leave-it basis. Such arrangements could also set precedents for eroding penalty rates among other groups of workers, including those who are lower paid. Some employer associations have claimed the bill will harm job creation and productivity. The evidence base for these claims is weak. Studies have found that previous penalty rate reductions have failed to deliver promised employment growth. Other studies have found that rolled up pay arrangements often result in underpayment due to inadequate reconciliation. Cutting penalty rates can exacerbate recruitment and retention challenges, especially in low-paid sectors with high job vacancies. This is because they can reduce job quality, which can drive workers away and worsen staff shortages, an outcome that is evidently bad for business. I see this bill as a necessary safeguard for ensuring the balance between efficiency and fairness that the award system provides is maintained. That is the summary of my submission. Of course, I'm happy to answer any questions you may have.
Thank you very much, Professor. I might kick off and then I'll come to the Deputy Chair afterwards. Professor, I appreciate the summary of your submission and you taking the time to make your submission. I want to ask you about some of the other evidence we've received to this committee to date to get your perspective on it. The Australian Retailer Association has claimed that their proposal, which is currently the subject of discussion, never sought to remove penalty rates from the award. But from the research you have done, what would you say in response to that claim?
I would say that they opened the scope for individual negotiations over roll-up pay arrangements in return for penalty rates. There's been extensive research that's been done on when individual negotiations are, when the opportunities opened up, what the consequences of those are. There has been extensive research done, particularly around the period of the work choices legislation, which essentially did exactly that. It individualised negotiations over pay and conditions. These were typically offered on a take it or leave it basis. This was especially the case for workers that lacked bargaining power by virtue of not having union representation, or by not having skills and that were in high demand. That distinction between collective bargaining power on one hand and individual bargaining power on the other. When workers lack those, take it or leave it arrangements are very common. Essentially, what this did was, according to a large range of studies that I could present, is that it increased employer power to set terms and conditions. Especially for new employees, this idea that arrangements can be negotiated is much harder for when someone comes into an enterprise and when arrangements are already established, in effect. Another kind of consistent finding of this research was that gender equality was especially undermined by individual pay arrangements. Individual negotiations were found, a consistent finding, to be detrimental for workers' wages. And I mean, there are some parallels here between annualised arrangements that are already enshrined in awards with sectors like hospitality, and I could speak a bit more to some of the research I've done there later. There's perhaps one last study I'll mention, which is a study led by one of the members of this committee, Senator Barbara Pocock, and with several other colleagues at my own institution, University of Sydney, and at RMIT here in Melbourne. It's a study of 121 workers in retail, in hospitality, in clerical, and in care, industries that are, I think, relevant to the work of this inquiry and this particular inquiry. So essentially, individual negotiations were presented on a non-negotiable basis. They were terms that were, as I said, take it or leave it. So they weren't really negotiations at all. These arrangements reflected or led to increased employer prerogative, led to a decline in job security, decline in penalty rates, and a decline in flexible work arrangements for employees, including those with care needs. So that is some of the relevant research that I think is worth the committee taking account of.
Thank you, Professor. Over the course of the debate around this legislation, we've heard claims that the bill, if passed, would impact on productivity or have an impact on jobs. Can you tell us, is there any evidence that cutting penalty rates or overtime rates leads to job creation or improvements in productivity?
They're two separate matters. I might deal with them separately. So taking job creation into account first, and then I'll turn to productivity. So when in 2017, the Fair Work Commission, there was a case brought before it regarding penalty rates, particularly on Sundays, in retail, hospitality, fast food and pharmacy. The Fair Work Commission had decided to reduce penalty rates on Sundays in those industries on the assumption, taking into account of various evidence that was presented before it, that this would stimulate job creation on those days, Sundays, where penalty rates were reduced. Subsequent analysis by academics Ray Markey and Martin O'Brien published 3 journal articles on this, found that this did not lead to increased employment. It did, essentially, the Fair Work Commission's predictions, the assumptions under which it made the decision did not hold. Why? Because, well, the key reason they focus on is that workers at a period of high increasing living costs and declining wages, the consumer spending was low. Retail and hospitality are sectors, 2 of the key, all the sectors involved in this hearing, but retail and hospitality among those rely upon consumer spending. And there's analysis done by those authors and also others that suggest that the Fair Work Commission's decision may have contributed to this diminished consumer spending, which did not lead to job creation. In their analysis and in the analysis that others have done, Martin O'Brien and Ray Markey, they did an extensive study involving a survey of employees and as well as employers and managers, and assessing employment outcomes in awards compared to other employment arrangements. They said that basically the Fair Work Commission's predictions didn't come to fruition because of unreliable data and also because of erroneous assumptions. They relied upon employer intention surveys, not actual outcomes, not what happened in the labour market. The assumption that it relied upon was essentially one that declining wages would increase jobs. But labour markets don't always work like that. They don't work like other markets. This has been demonstrated comprehensively by organisations like the OECD, a very dispassionate organisation when it comes to labour market matters. Essentially, when workers' overall wages decline, this can affect workers' attachment to their jobs. It can diminish their satisfaction. It can diminish their productivity. It can diminish retention. It can, in that sense, that last point can increase employers' staffing challenges, leading them to spend more time on recruitment and training than on other things. Essentially, the assumption that that declining wages will lead to job creation, in reality, often doesn't happen. What it often does do is it increase profits. A recent study by Per Capita found that over the past decade until 2022, the wages share of income in the economy fell by about 3.6%. That decline went essentially to profits. So the assumption that employers will reinvest the surplus from decline labour costs hasn't been borne out by those studies. In terms of productivity, I kind of touched upon this to some extent already in the answer. Look, the relationship between employment arrangements and productivity is tenuous. Productivity is driven by many different factors, including investment in technology and utilisation of workers' skills and of capital investment. The Productivity Commission last year, in its productivity bulletin, had found, as many other analyses have found, that there's been a decoupling between productivity and wages for a long period of time now. The argument that annualised pay arrangements will increase productivity, I've not seen any evidence to suggest that would likely occur.
Thank you. And I mean, you've covered a bit of this in your answer, but are there any further consequences you can speak to for businesses if penalty rates and overtime is cut? I mean, what would the impact on business ultimately be? And I'm thinking, in the ability to retain staff and fill positions and that sort of thing, but any other consequences you might like to talk to as well?
I mean, there's been studies on the wider economic effects. There was a Centre for Future Work study I cited in my submission, looking at penalty rates are taken out of the economy. That takes $14 billion out of the economy, which is important for growth, in terms of consumer spending. it's understandable for businesses to always seek ways to become more efficient. But I mean, I think that what often we have seen we're seeing here is that the time horizon for efficiency is often exclusively short term, in the sense that reducing operating costs that might lead to some short-term benefits for business. Those benefits often will come at the expense of the workforce. There are plenty of research, including research I've conducted, whereby businesses who invest more in their human resources, in their staff, tend to see productivity dividends in terms of staff who are willing to, or who are more inclined to stay in their jobs longer, to be more satisfied in particular, and often to work harder as a result. And then associated with that, because retention is less of a challenge, this diminishes challenges around or resources devoted to recruitment and training. And as a consequence of this, wider challenges for that industry around staff shortages tend to be less acute. So the industries where pay is lower, where job quality overall, of which pay is one component, is lower, tend to have more acute challenges around staff shortages, which create problems for business. So I hope that answers your question.
It does, thank you. And just one more question from me. I was wondering if you're able to speak to the link between, or the significance of the payment of penalty and overtime rates and gender equity in pay in the workforce. There's a gendered element to this, isn't there?
Well, there is. I mean, the research, Hilda's survey data that I cited in my submission, also data from the ABS, Australian Bureau of Statistics, indicates that award-reliant employees, in other words, those who rely upon awards to get pay increases or to get protections in their employment, disproportionately are women, and the industries that are the subject of some of the cases before the Fair Work Commission, like retail, 55% of workers in that industry are women. So, yes, there is a gender dimension to this, certainly.
Thank you, Professor. I'm going to pass the call to the Deputy Chair, Senator Kvasik.
Thank you so much. And thank you for your time today and for your submission. I'm also particularly interested in productivity and flexibility, and I asked a question to the earlier witnesses around the right of employees to negotiate their own flexible arrangements. And particularly in the context of, the ongoing discussion in our country around work from home and the value that places, and there's a lot of data and research that says people actually value work from home more than they value financial or higher pay, right? So I'm wondering what you think about the principle that, on one hand, that's saying that an employee should not be worse off at all. So then how much weight do we then give to the practical benefits that can come with a higher rolled up rate, which I mentioned earlier of, the greater ability to budget, improved borrowing capacity, steadier super, and reduced volatility in income-tested Centrelink payments. And that one particularly is an impact for women, and I am part of a lot of different women's and mothers groups who actually talk about the challenge of estimating income to Centrelink and child support, and then getting that wrong because of the variances in penalty rates, and then having to pay back these government agencies. Like, how do we sort of weigh that all up? And is the not financially worse off actually the best test?
Well, it's a very good question, Senator. Thank you for it. I mean, there's a distinction that's made within a lot of the research on job quality, which tries to put pay alongside other things that employers value, between objective measures and subjective measures. And objective measures are things that are deemed to be things that kind of everyone or most people want. Good pay is typically something that people value, but as you noted, to varying degrees. It depends upon people's needs, circumstances, the intrinsic reward they get from their work. hours, working hour arrangements that allow them to balance work considerations with family considerations, progression opportunities. These are things that are typically put in the objective category, and then subjective things are things like often remote working arrangements. Different employees place different value on that depending upon the nature of their work, upon their own circumstances. So, I mean, the Fair Work Commission, when it's tasked with making decisions around matters that are before it in terms of award or enterprise agreement applications, or when it is assessing those things with reference to legislation like the Fair Work Act, is typically looking at the objective measures. So it's looking at what people's pay is, what their income might be. Things like working from home arrangements are harder to take into account because, and also, and I think the other aspects you mentioned in terms of pay versus social security payments, they're harder to take account of, partly because of the subjective value in some cases, and also the matters that go beyond the Fair Work Commission's remit in terms of those social security dimensions.
Yeah. So, so do you think then that can sort of unfairly sort of impact people that those measures do matter to? Like, I guess what I'm trying to understand is why we're being so prescriptive on this and why we don't just allow the current process with the Fair Work Commission and their powers. Like, why do we have to legislate this? The earlier witnesses suggested, because it creates protections and assurances, but it also does create prescriptiveness and barriers as well. So I'm trying to understand what the problems are with the current circumstances, and is this, going one step too far?
Look, yeah, it's a good question. Look, I think it reflects the value that's placed on pay, and I think that is legitimate in given that until quite recently we've had a prolonged period of lower wage growth. That the award system itself, as a proportion of like the national minimum wage, which flows throughout the award system and underpins all of our 121 modern awards, as a proportion of median earnings or income in Australia, it's diminished quite significantly from around 65% to around 55% over time. So I started my opening statement by saying the award safety net is a very important part of maintaining fairness within the Australian labour market, while also the system also allows considerable efficiency and flexibility for employers. So I think that it is important to underscore the value that we place on wages within the award system, because a lot flows from that. People's ability to be able to, we all hopefully get some value out of our jobs. Unfortunately, not all of us do, but that often a precondition for that is feeling like we can cover our basic living costs. So I think especially for those who are at the lowest paid segment of the labour market, it is particularly important to protect their existing position.
Yeah. And do you think there's an argument in that if they wish to sort of roll that all up and have that consistency of payment, that in itself is beneficial if that's what they choose? Or do you, because some of the concerns I have is, some of the evidence or submissions suggest that, employees aren't able to make these decisions, or they can't, or if they are making them, they're making them from a position of an imbalance of power, and they can't make choices for themselves. Whereas I sort of hold the view that, people can decide whether, I want to know that that's going to be my pay, and I might get, half a day off here, or I might do X or Y, or whatever it is that I've negotiated with my employer. Why does it need to be so prescriptive? Why do we have to say that this is how you have to do it? And why are we carving out the ability of the Fair Work Commission to actually make determinations if there is a problem?
I think, look, there are a couple of elements there. So I might start with the last part first. I don't think, the Fair Work Commission, I guess, is constrained by various elements of the Act. Like, it has to make decisions around awards as well as other matters with reference to the Act. And this is adding another dimension to it. Look, my reading of the legislation is that it won't prevent rolled up arrangements from happening. It will just prevent them from happening when it's going to lead to an overall lower pay arrangement, and that's a legitimate concern. Like, if I could reference one of my own studies that I conducted with two colleagues at the University of Sydney. It was led by one of my research students, but published in two well-regarded journals. It was on these arrangements in the hospitality sector, especially specifically in high to medium end restaurants and among chefs. So the study was about recruitment and retention challenges in that amongst that cohort of workers in that industry. This is a group of workers who, hospitality is not a unionised industry outside of major hotels. But chefs, in the context of that industry, chefs have a high degree of individual bargaining power, especially at the high to medium end of the restaurant segment. We'll see, like every night we go home and it's there on primetime television, MasterChef. And
they don't seem very vulnerable.
Well, but in this situation, in many respects, our study reflected that they weren't. But at the same time, annualised arrangements were the norm, and they weren't negotiated. They were presented. Like this is the arrangements that we have in place, and this was a study of 6 restaurants. 34 people were interviewed as part of this, including managers and owners as well as chefs. But what we found was that people were typically getting paid less than what they would have otherwise been if their salaries had been reconciled with the hours that they actually worked. In some cases, people were getting paid far less, and beyond pay, the findings were very revealing for the ability of people who are very passionate about their jobs to keep doing it. So because because pay was rolled up, it meant essentially overtime wasn't paid. This is an industry where long hours is kind of a norm, but
probably the longest hours of any industries, I guess.
Yeah, but the rolled up pay arrangements really just encourage this, or maybe they were already in place, but it really encouraged this, in cases of people working 17 hours a day. For people were willing to put up with this, but only while they could, essentially. We have quotes from the study, from women saying basically the long hours, which were promoted by the poor implementation and the failure to regulate annualised salaries, in practice led employers to schedule as many hours as they desired with no consequence, despite the requirement to reconcile hours with the hourly rate provided in the award. Workers reported, I never saw my friends on weekends. But those with families, that they could, there were places that they just couldn't work. If their expectation was you work 80 hours a week or 7 hours a day, then that just wasn't possible. And it led some workers to leave the industry and to leave their profession that they cared passionately about. One worker said that it basically you'd have to give up your career to have a child. Most people in kitchens find it hard to have relationships, never mind children. So, these inadequate arrangements around the regulation of pay can be life-changing, not in positive ways. It can force people to choose between their career and the prospects of having a family. So, yeah, I think that therefore some protection for workers at the lowest end of the pay spectrum is necessary to ensure that not just for balancing efficiency and equity, but for wider social considerations as well.
Thank you. I guess my question was more about that balance where people are choosing to negotiate that flexibility. But I get your point in relation to that. And I'll just finish on this one. Do you sort of have a view that or, you know, the research that you've done, that, you know, is it you're saying that the majority don't benefit from rolled up arrangements where they choose to participate in those, or is it just a smaller group that don't? Are there anomalies, or is it entirely inconsistent? In some circumstances, some may benefit and others won't?
I think the challenges have been less evident in the higher paid industries. Like in, I did take a note of of those in my notes, but they have been challenging in industries like hospitality. I mean, these sorts of there's been cases in before.
So there are more industry-specific challenges as opposed to a broader set of challenges, perhaps.
Well, I think that the bill, as I read it, wouldn't prevent these arrangements from happening in areas in industries where pay rates tend to be higher, where individual employees tend to have more bargaining power by virtue of the dynamics of their industry and also their own position. But in the industries, like I think in retail in particular, there are some strong parallels with hospitality where these arrangements have led to challenges, not just for workers, as I just articulated before, but also, contributing to, I would say, entrenched problems around staff shortages. Low job quality, leading employees rather to choose other industries, which then makes it harder for employers to attract and then to retain staff. So, so I think while these arrangements have a legitimate role to play, I would say not at the expense of, not if they undercut people's overall wages. And I would see. I mean, the flexibility question is a very important one. I mean, we're having lots of debates in this country and other countries on this very day. For example, there's reports about 4-day work weeks and flexible working arrangements in the media over the past few days.
And that's where the challenge is for me, right? We're talking about the critical importance of it here, but then removing it from the decision making here, particularly when perhaps the majority stand to benefit. But if there's a few that don't, then the majority can't have that.
Yeah, I don't think they're in conflict. I think you can still have protections around people's overall pay packet while still allowing scope for flexibility where it makes sense.
Thank you. It's been a very interesting. Thank you, Chair. Yeah,
Thank you.
Very interesting chat. Yeah.
Senator Pocock. Senator Pocock.
Thank you. And thank you, Professor Wright, for being here. I think you have comprehensively dealt with a couple of areas of my questioning which related to the employment effects and to the gender pay equity issue, so thank you. Did you hear the earlier evidence from the unions that were here in the ACTU?
Senator Pocock, no, unfortunately I wasn't able to make the earlier session.
Yeah. No, I'm interested in pursuing your views about an issue they raised, and you've already been talking about the relationship between working time and award provisions and wages. They raised the issue about record keeping of hours and the implications of exemption rate or rolled in rates for record keeping, and their view was, as I understand it, that rolled in rates don't have the same requirements for record keeping, and I think you've already sort of referred to this, and that can lead to uncapped and uncontrolled working hours, and that they would like to see provisions that do require this record keeping, which are then exposed to scrutiny. Do you agree with that line of argument?
Yes, I do, and also I think that I know some of the submissions that have been made around the burdens of record keeping, which I sympathise with from a business owners. With business owners for that in that respect, but I would also note that technological improvement has aided record keeping substantially. It's a lot easier for businesses, including small businesses, to keep records than it was 5, 10, 20 years ago.
So thank you for that point. You were giving evidence just a moment ago about some of your research which showed that annualised hours led to an expansion in the length of the working week, which was had a negative effect on the employment, especially of those with caring responsibilities and possibly also for fertility decisions and relationship possibilities. Which sector was that evidence from?
That was from the restaurant sector, Senator, and it was from the medium to high-end restaurant sector. So it was among workers who would be able to negotiate arrangements more easily, I think, that were in their favour than, say, in other parts of hospitality.
Right, so relatively skilled workers, one-on-one relationships with their employer that gave them power, but still found their hours extended, in some cases to quite unhealthy levels. Is
Yeah, up
that right?
to 80 hours a week in some cases.
Right, well, we know what the research evidence says on that. Would you like to comment on what long hours do to people and what the body of research evidence says about that?
Well, I guess to sum up, increased fatigue, increased burnout, declining attachment to their jobs, but also to their it can have negative effects upon relationships. It can lead to the research highlighted that it can lead to substance abuse issues for people trying to deal with this stress. So wider social consequences beyond the workplace.
Yeah, thank you. I heard you comment, I think, about the profit share and the increases in profit, and the FSU earlier this morning talked about today's announcement of the CBA profit up by 4%, 10.25 billion on the last financial year. It is possible, is it not, and do you want to make a comment about this, that this kind of measure, if the employer application were to succeed, would further shift profit shift to have the effect of increasing profit and shift from profit and income from wages to the profit share. Is that a fair statement of what the research evidence says historically and what's underway now?
Yes, it is, I think. I mean, there's been a lot of research done by David Peets, for example, who has who looked at the effects of changes in employment legislation and rules on productivity versus and he concluded that arrangements that effectively that deregulate or that increase employer prerogative in some way or open the scope for individual negotiations don't positively impact upon productivity. If anything, they diminish it, but what they do is increase profits.
Thanks for that. A couple of clarifying questions about the provisions in the bill. Professor Andrew Stewart has raised some questions in his submission about what qualifies as a rate reduction, and he said that while the rate of the penalty could not be reduced, the circumstances in which they could be applied might be changed. For example, changing the span of hours in which ordinary hours applied on a Saturday without a penalty applying. That would cut take-home pay for a worker without explicitly reducing the rate paid. In your view, if this bill was passed, would it still be possible for employers to change the scope or circumstances under which penalty and overtime rates apply? And could the Fair Work Commission narrow the circumstances under which penalty rates and overtime rates apply?
Thanks for the question, Senator. I read Professor Stewart's submission with interest and greatly respect his legal expertise on these matters. I then, I read it a couple of times and also referred back to the explanatory memorandum and the Department of Employment and Workplace Relations submission. I feel that those two, the due submission and the explanatory memorandum, make it clear that existing arrangements under existing awards wouldn't be affected. Unless the Fair Work Commission were to decide that the existing arrangements within an award, when it comes up for review again, don't fulfil the modern award objectives, which are multiple. So I think that they're good points that Senator Stewart raises, but I felt that there is sufficient clarity in the existing documentation or in the existing provisions.
Great. Thank you for clarifying your perspective on that. And the last question, also about the scope of the Fair Work Commission's powers. I understand that on the 31st of July, the government passed an amendment to the bill in the lower house that sought to clarify that, quote, nothing in subsection 1 requires the Fair Work Commission to exercise its powers under this part to make, vary or revoke modern awards, end of quote. However, there are people out there still with concerns about this. Is it your understanding that this bill would not require the Fair Work Commission to review penalty and overtime rates in an award if that is not the primary focus of a review?
Yes, that is my understanding.
Okay, very clear, short answer. Thank you very much, and that's my questions done, Chair.
Beautifully timed, Senator Pocock. Thank you. Professor Wright, we really appreciate your participation in our inquiry today, as well as the effort you made to place a submission with us, so thank you very kindly. I don't think you took any questions on notice, but in the event I missed one, 15th of August is the due date, but you're free. Yes, well, it's a quick turnaround, but you're free to depart now, so thank you so much.
Thank you, Senators.
The committee will now suspend. We'll be resuming at 12:45. Thank you. Hearing, and I'll just confirm broadcasting. We're all good. Lovely. I would now like to welcome our representatives from AI Group, from the Australian Chamber of Commerce and Industry, the Australian Retailers Association, the Business Council of Australia, and the Council of Small Business Organisations Australia. I understand that information on parliamentary privilege has been provided to all of you. For the Hansard record, I'd like each of you to state your full name, please, and the capacity in which you're appearing today. And we'll start with Mr. Swenson and move down the table, please.
Thank you. Brian Swenson, Director of Policy at the Australian Retailers Association.
Good afternoon, Senator. My name is Sean Schmidtke. I'm the Director of Workplace Relations Policy at the Australian Chamber of Commerce and Industry.
My name is Brent Ferguson, Head of National Workplace Relations Policy for the Australian Industry Group.
Kat Ether, General Counsel for the Business Council of Australia.
And Mike Summerton, Head of Industrial Relations for the Council of Small Business.
Lovely. Would any of you like to make an opening statement? Yes. All of you. Would you like to organise yourself, or would you like me to choose? Who'd like to kick off? Mr. Ferguson, your hand's up. Off you go. Yeah.
Look, thank you, Chair and committee members, for the opportunity to appear today on behalf of the Australian Industry Group. We've lodged a detailed submission last week that sets out our concerns over the substantive changes proposed by the bill, as well as concerns over deficiencies in the drafting. We've also provided a short supplementary submission yesterday that I understand the committee's received. That provided some additional context around the notoriously unworkable record-keeping requirements regarding hours of work that are contained in awards, and that have, in part, been a catalyst for the applications or proposals that AI Group has advanced for exemption rates to be included in the Clerks Award and the Banking Award, and which, of course, have been the subject of debate in the context of these proceedings. As we've set out, our group is deeply opposed to the flawed and entirely unnecessary bill. It will fundamentally and problematically undermine the integrity of the legislative framework governing the making and varying of modern award terms. Moreover, it frankly reflects a disturbing and unwarranted lack of faith in the independent umpire, the Fair Work Commission. By limiting the Commission's power to vary awards...
Sorry, Mr. Ferguson, I might need to ask you to speak up.
Oh, yeah,
so we
of
can
course.
Or move your microphone from the middle,
forward,
just
yes.
so the audio. Thank you, Mr. Ferguson.
Yeah. Look, the point we're making is that by limiting the Commission's powers to vary awards, even in circumstances where the change may be beneficial to employees and in the public interest, it will stifle the Tribunal's ability to both address known problems in our notoriously complex award system and to ensure that awards evolve to reflect inevitably changing circumstances of both workers and employers in the future. Instead of trusting the Commission to ensure awards remain fit for purpose, the bill will, in our view, inappropriately lock aspects of the current award terms in stone. Now, before addressing any questions, I really just want to emphasise that the bill is, unnecessary for two reasons. And the first is that, the legislation, Section 134 to be specific, already requires the Fair Work Commission to ensure that modern awards, together with the NES, constitute a fair and relevant safety net of minimum terms and conditions. Now, that notion of fairness as contemplated in the Act requires a balancing of the perspective of employers and employees, but under the legislation, in terms must ultimately be fair. It's not possible for the Commission to implement any unfair terms in it. And the other point I would emphasise in that context is that Section 134 already contains a specific protection for penalty rates in that it requires the Commission, when taking into account fairness, to consider the need for additional remuneration for overtime, working unsociable hours, weekends, public holidays, etc. And the other point I'd make on necessity is that the committee shouldn't lose track of the fact that there's been very few applications directly aimed at reducing the quantum of penalty rates, which is part of the mischief that this bill purportedly seeks to address. And even where those applications have been advanced, they've been dealt with exceptionally, frankly, remarkably carefully and in a very cautious way. I mean, I can provide further context for those proceedings, but they were not dealt with lightly. And the other point I'd make is that, as far as I'm aware, there is no application on foot currently to reduce penalty rates in awards. Look, the only other point I'd make is that we have proposed amendments, notwithstanding our opposition to the bill. We've sought to constructively improve it and at least modify some of our concerns. They go to the substantive issues we've raised, as well as the drafting deficiencies, and happy to answer questions on those, but I'd urge the committee to grapple with that detail. Thank you.
Thank you, Mr. Ferguson. I'd like to go next. Yes, Mr. Smith.
Thanks, Senator. The Australian Chamber of Commerce and Industry is grateful for the opportunity to appear before the committee today to assist with its inquiry into this bill. As the committee is likely aware, ACCI is recognised under the Fair Work Act as a peak organisation of employers. We have a membership of over 90 separate member-based industry organisations right around the country, including all state and territory chambers of commerce and a range of other national and sector-specific industry associations, including the Retailers Association, the Hospitality Association, and a range of others. ACCI does not support this bill, and we would urge the committee to recommend that it not be passed by the Senate. The grounds and reasons for this position are outlined in the written submission as filed with the committee. I'd be happy to take the committee through any of the detail of that submission as required. However, in summary, we say that the basis for this bill is fundamentally flawed. Its provisions are completely at odds with the needs of contemporary Australian workplaces and the need to ensure a modern 24/7 globally competitive economy. The bill goes further than the stated election commitment, locks unnecessary rigidity into the Fair Work system, undermines the independence of the industrial umpire, and unfairly restricts its capacity to ensure that modern awards suit the needs of those to whom they apply. Because of the way the provisions of the bill are drafted, it will make the future pursuit of modern award terms that provide flexibility for workplaces, simplicity for business and certainty for workers virtually impossible, even if this is what the Commission independently decides. This will restrict the ability for business to provide flexibility that employees increasingly demand, such as the ability to work from home or other hybrid working arrangements where they mutually agree. Worse, the uncertainty associated with the scope and operation of the bill clearly opens the door to remove modern award terms that achieve those outcomes where they already exist and have done so for decades. This will remove certainty and stability for workers, restrict the ability for business to respond nimbly to changing operational needs, and force employers into a methodology of determining penalty and overtime rates on a prescriptive, resource-intensive, time-consuming and inflexible hourly basis. By locking in the practices of the past and removing the ability to deal with the challenges of the future, this bill fails to recognise that the broader community debate has moved on and has embraced the reality that the world we work in is rapidly changing, as is the way we work and as are the attitudes of those who perform that work. For these reasons and the others detailed in our submission, we say that the bill represents a backward step for employers, workplaces and employees and is not supported by ACCI. We again urge the committee to recommend the bill should not be passed by the Senate and thank the committee for the opportunity to appear before you today.
Thank you so much. Mr Swenson.
The ARA and the NRA together represent a sector that employs 1.4 million Australians, or 1 in 10 working Australians. We represent the national and international retailers that support thousands of jobs in metropolitan and regional Australia. We represent small and independent businesses, which make up 95% of our membership. We are aware that the implications from the passage of this bill will be reaching far beyond the retail sector. However, as our application to introduce an exemption rate into the General Retail Industry Award is currently before the Fair Work Commission, we feel it is extremely important to clarify and clearly outline the facts of our proposal and how the bill may impact these proceedings and the employees that stand to benefit. Penalty rates have an appropriate place in our award framework, recognising the hours and times lower paid Australians work. That is why at no point does our application seek to remove or reduce penalty rates or overtime from the award. Our proposal to include a salary exemption rate only applies to selected employees under the GRIA, those on level 4 and above, such as department or store managers. In addition, when considering a proposal such as an exemption clause, safeguards play a critical role. In our application before the Fair Work Commission, we have carefully designed safeguards to protect worker rights, providing them with choice, flexibility, and greater pay certainty. This includes a voluntary opt-in clause for employees, capping working hours at 43 hours per week before additional payments kick in, and maintaining separate entitlements in relation to public holidays and breaks. Based on the 17 rosters originally selected by the SDA in evidence, with these safeguards in place, those workers would be on average $5,861 better off each year. This is based on the rosters provided by the SDA. This is in addition to the benefits that a more consistent salary provide and the greater flexibility within their role. We therefore oppose the passage of this bill. It undermines the independence of the Fair Work Commission in carrying out its statutory functions, which already includes an obligation to ensure that modern awards provide a fair and relevant safety net of employment conditions. By prohibiting any award variation that might theoretically reduce penalty or overtime rates for even a single employee, the bill would foreclose sensible, evidence-based reforms that simplify awards, support compliance, foster flexibility, and lift productivity. That is, if even one employee out of the 1.4 workers in the retail sector may be worse off, such a proposal would not be adopted, despite the proposed safeguards that one employee would still have the choice to opt in. It is important to highlight that the bill, as currently drafted, does not introduce a principle, rather it introduces a complicated prohibition. As drafted, the bill leaves the Commission with no discretion. The bill would even prohibit a variation to an award on the Commission's own motion or a variation that was supported by the relevant union and that would deliver uplifts in entitlements for a significant portion of the workforce. The ARA is also concerned that the bill seeks to limit the powers of the Commission to reduce award complexity, a problem widely acknowledged by industry stakeholders. The ARA's application to the Commission to vary the GRIA followed on from the former Minister for Employment and Workplace Relations, Tony Burke, encouraging the Commission and parties to use the review of modern awards to identify opportunities to make awards easier to use. Our proposal contains significant benefits for employees and employers of all sizes, right across the sector. If this is not permitted in the award, it is not realistic that this benefit will ever become available to most employees through enterprise bargaining, most notably those in smaller businesses. In summary, the ARA and NRA recommend the Senate does not pass the bill. There is no case for this legislative intervention which would permanently restrict the Commission's ability to appropriately respond to changing conditions over time. We thank the committee for the invitation to appear today and to contribute to this discussion on behalf of our members.
Thank you. Mr Somerton.
Thank you, Chair. Thank you, committee members. I'm speaking on behalf of the Council of Small Business, a national peak body representing small businesses across Australia, businesses that collectively employ over 5.2 million Australians, representing 97% of all Australian businesses. We also urge this committee to reject the bill in its current form. This change represents the 36th major change to the Fair Work Act since 2022. Of the 35 major changes thus far, 34 disproportionately affect small businesses like a cafe with 5 employees, just as much as it does a large corporation with 10,000 staff or more. The bill fundamentally misunderstands how small businesses operate. Unlike large corporations with specialist HR teams, small business owners personally handle compliance with Australia's already complex industrial relations system. Small businesses rely on modern awards. The take-up of enterprise agreements by small business is extremely low, less than 5%, as they do not have the resources, time, nor investment capacity to invest in the negotiation of an enterprise agreement. Changes to the Fair Work Act since 2022 have made it harder, not easier, for small businesses to want to even contemplate the making of an enterprise agreement. Processes of approval by the Fair Work Commission can be bureaucratic, technical, cautious, making the approval process itself slow, cumbersome and unpredictable. Small business relies on modern awards, and making flexibility easier with respect to the management of those awards, not harder, is critical for small businesses. The legislation also undermines the industrial relations system itself. The Fair Work Commission was established as an independent umpire to make evidence-based decisions balancing the interests of employees, businesses and the economy. By removing the Commission's discretion to vary awards in key areas based on changing circumstances, this bill converts it from an independent decision maker with an unjustifiable, narrower focus. We are particularly concerned that the bill makes no distinction between small and large employers, despite our vastly different capacities for compliance and negotiation. The legislation, in our view, is unnecessarily rushed and ill-considered. Our recommendations are straightforward. Retain the Fair Work Commission's role to conduct rigorous independent assessments and award variations, with all parties being heard on any matter pursuant to wages that potentially allow for greater flexibility, still meeting the better off overall test. Other options include the deferral of the legislation for a proper and considered analysis to determine the correct avenues for an explicit carve-out for small business. One method, but not the only method, is to note that there are several awards that predominantly cover small business sectors across the economy that, in our view, should be afforded exemptions. Sectors like hospitality, cafes, restaurants, hairdressing, beauty salons, fitness, landscaping, dry cleaning, laundry, pharmacy, gardening and landscaping sectors, to name but a few. In closing, small businesses are the backbone of our economy and yet have faced constant regulatory assault. The one-size-fits-all approach, the 36th proposed major IR change in just 3 years, enshrines inflexibility and narrows the role of the independent umpire with the very industrial instruments that small businesses rely on. In Cosboa's view, this bill should be deferred for further proper analysis, or better yet, rejected outright. Thank you, Chair.
Thank you. Ms Ether.
Thank you, and thank you for the opportunity to appear before the committee today. As our submission makes clear, the BCA does not support this bill. The bill is unnecessary and counterproductive. The bill limits the options for working arrangements that can be tailored to fit the needs of individual employers and their employees. This restriction hinders the ability of business and workers to agree on mutually beneficial and productive working conditions. With productivity growth falling to a 60-year low over the past decade, Australia needs to increase labour productivity, not lock in rigid and inflexible working arrangements. The Fair Work Commission has been granted extraordinary new powers in recent years, powers described as justified due to the Commission's expertise, impartiality and professionalism. They have also long been tasked with creating and varying modern awards and setting fair and balanced minimum wages for Australian workers. Other powers recently provided to the Fair Work Commission include powers to set minimum standards for gig workers and road transport contractors, powers to determine unfair deactivation and termination disputes, powers to resolve disputes and determine working arrangements in private enterprise in relation to flexible work requests and the right to disconnect, and powers to determine the terms and conditions of employment, including penalty rates and overtime loadings, where bargaining has become intractable. The Commission is tasked with doing this in line with the objects of the Fair Work Act and the Modern Awards Objective. Elements of these objectives include requirements to consider the need to promote flexible modern work practices and efficient and productive performance of work, the likely impact of modern award powers on business, including on productivity, employment costs and regulatory burden, and the need to ensure a simple, easy to understand, stable and sustainable modern award system. As a principle, this amendment is at odds with the independent status of the Fair Work Commission, and as well as protections in place to ensure it operates for the benefit of employers and employees. It is therefore hard to believe that the Commission will be constrained to decide award matters on their merits. The bill also restricts the Commission's discretion in relation to overtime loadings, which were not part of the government's pre-election commitments. This is not just an issue for the retail sector. Absorption clauses are a long-standing and widely used feature of many modern awards, applying across a range of industries. For example, absorption rates are included in the business equipment, registered and licensed clubs, market and social research and professional employees awards. They have worked successfully and fairly for years, providing a practical mechanism for employers and employees to agree on pay arrangements that suit both parties. The Fair Work Commission has a long history of establishing such arrangements subject to appropriate safeguards and protections for workers. It is important to note that these arrangements do not remove penalty rates or reduce them, but rather provide for them to be absorbed into higher base rates of pay subject to appropriate safeguards set by the Fair Work Commissions. The bill is also underpinned by a flawed and contradictory rationale. The so-called principle is in fact a confusing restraint on the Fair Work Commission, preventing it from properly considering and determining applications based on the Modern Awards objectives and the evidence before it. This will limit the flexibility needed to respond to modern workplace realities and to create better jobs. It could also have other unintended consequences in relation to the interpretation and application of awards. What this bill could mean in practice is that the Fair Work Commission is unable to include higher base salary terms in awards, such as the banking and finance industry, that significantly benefit a large number of finance workers by increasing their pay and allowing flexibility in when their hours are worked, even if the arrangement was supported by unions and requires individual agreement. This could result in less flexibility in working patterns for workers, and employers will need to be cognisant of each employer's entitlement to overtime penalty rates when rostering, as well as a less predictable pay packet from pay cycle to pay cycle. It also leaves employers with a complex and unwieldy compliance burden at a time when we want to lift productivity and reduce red tape where we can. By removing the option to assess and approve sensible salary arrangements in awards, the bill would diminish opportunities for productivity-enhancing outcomes and flexible working patterns for employees. It also undermines the independence of the Fair Work Commission, sending a troubling signal that the government will legislate when it dislikes even a potential outcome of a process it has otherwise empowered the Commission to conduct. In short, the bill is unnecessary, inconsistent with previous government actions, could have unintended consequences, and risks making our workplace relations system less flexible, less independent, less able to deliver flexible and desirable jobs for Australians. Thank you.
Thank you, Ms Ether. I'm going to pass the call to Senator Kovacic to kick us off. Senator Kovacic.
Thank you, and thank you all for being here today and for the evidence that you have provided. I've listened to each of your statements with great interest because I had a deal of confusion this morning in understanding some of the evidence from the unions, particularly in the manner in which they suggest that, or they were suggesting, and I asked this question, that there was an attack on penalty rates, and that's why we need this legislation. Can you sort of give me an understanding of, is there a campaign to remove penalty rates? Is this what, is currently happening in the environment, in the workplace environment? I'm not seeing it. I'd like to understand what you are seeing, in the breadth of, representing larger employer groups and smaller employer groups. Is there a campaign to get rid of penalty rates in this country?
Thank you, Senator, for the question. I might start with that one. I guess, first of all, we fully reject the notion that we are looking to reduce penalty rates or overtime. And the second aspect that we have tried to clarify over recent periods is that this applies to all workers covered by the GRIA. It's clearly not true. It's for workers that are of managerial or more senior positions. As I stated in the opening, the Retail Industry Award is one of the most complex awards. There are 994 individual pay rates across 96 pages. It is incredibly complex. And as we responded to the invitation to modernise that award, we put forward an application with genuine intent to look at solutions that could deliver benefits for employees, as we've highlighted, protecting penalty rates, and also delivering flexibility while making it easier for businesses.
Thank you.
Yeah, full context. I mean, I'm not aware of any sort of coordinated campaign to attack penalty rates. If I think about that through the prism of the Commission proceedings that are on foot, again, as I've already attested to, I'm not aware of any actual application on foot that is seeking to reduce the quantum of the penalty rate, which is what this bill is at least partly or primarily directed at. As I've said, there were a small number of very major cases run several years ago now that looked at the penalty rates regime in some specific awards in the context of some specific industries, and in those particular circumstances, in some cases made modest changes to some penalty rates. So, for example, in the fast food industry, for some classifications, there was some modification of penalty rates in recognition by the Commission of factors such as the wishes of employees, the fact that they want to work at the hours that those penalty rates applied, and that there would be some disincentive to offering work at those hours, and various other factors, including the changed nature of Sundays and so forth, and the practices in those industries. But I'm not aware, as I say, of any other case that's actually on foot that's seeking to reduce the rate. Now, we have advanced proposals for exemption rates in two specific awards. So one is in the Clerks Award, and then we've also responded to another employer group's application to vary the Banking, Finance and Insurance Industry Award to propose an exemption rate too. But again, that's a very targeted proposal dealing with specific issues and trying to provide some benefits to employees and employers in those sectors. And the point I'd make around those exemption rates is exemption rates are an entrenched feature of our workplace relations system. Historically, in clerical awards, the norm has been for them to contain exemption rates. And what we're seeking to do is put an exemption rate into that clerk's award. We've advanced a proposal. Of course, that case has a long way to go. And the Commission's still got to work through what impact that should have on penalty rates, what safeguards and so forth. But of course, that would impact penalty rates, but we're not, campaigning against penalty rates per se. They would still apply as the default.
Sure. And in your view, is the Fair Work Commission capable of protecting penalty rates without this legislation?
Yeah, of course it's capable of protecting penalty rates. As I said, the statutory scheme requires the Commission to ensure that awards constitute a fair and relevant safety net. So fair to employees, but also relevant to contemporary circumstances, is what that means. And it is in the scheme, it's actually compelled, when it's assessing fairness, to take into account the need to provide additional remuneration for unsociable hours, for weekends, for public holidays and so forth. But of course it must balance that against every other consideration in deciding whether or not to grant penalty rates. Now, for context, there was an application run in relation to the Hair and Beauty Award a number of years ago. The Commission flagged that it thought the penalty rates might need reviewing. AI Group and another association advanced a proposal to modify those, and after a detailed hearing, the Commission decided that the reduction in penalty rates wasn't justified or appropriate, and it declined that proposal. So it is established.
Demonstrated their ability.
And I want to give the committee an idea of the scale of these cases. I mean, that penalty rates case, I think it was 2017, it culminated in relation to certain hospitality sector awards, the fast food award, retail award. I think there were something like 139 lay witnesses that appeared in that matter. It went on for years. I think there were weeks of hearings. I think there was something like 6,000 submissions filed. There was expert evidence. The Commission dealt with that in an exceptionally sophisticated way, and only after carefully dealing with all of that material did it decide that actually it was appropriate and fair, when you looked at the balance between employers and employees and all of the circumstances, to implement a small number of modest changes, and even then it transitioned them, phased them in a very long way to modify any adverse impact on workers. So, we say that the Commission is the body that is well placed to deal with these complex considerations and to work out what is best for the country and how the awards should be framed so as to help us navigate changes in circumstances.
Okay. One other question for all of you, and then I have some specific questions. I just want to get an understanding of how much consultation any of you had with government in relation to this, and particularly if they shared any economic modelling. And I'm particularly interested in any modelling that may have been shared with you in relation to impacts to small business and the additional imposts to them. And Mr Summers, I note your opening statement where you talk about, the 35 pieces of legislation in the last 3 and a bit years, which is effectively, one new piece of legislation every month if we, sort of averaged it out in that way, and whether there is a potential a suggestion that is a factor perhaps in the record insolvencies that we're seeing in Australian small businesses at the moment, that this is just too much, yet another layer of unnecessary compliance and regulatory burden on all business, but particularly small business.
Thanks, Senator. The 35 number that I've mentioned is the number of major changes that have occurred to small business. The key point there is the expectation on a small cafe owner or a small butcher or a baker to expect to navigate the complexities of the industrial relations system just as much as a Woolworths, Coles, with deference to my colleagues here, but they have ample resources to deal with the complexities of this legislation. Small businesses do not. Now, in terms of your question on consultation, we were a part of the National Workplace Relations Consultative Committee where this was mentioned on the agenda by the Minister. We weren't part of the call process, but my colleagues were. But in terms of deep consultation, as to the effects of small business, the impacts on small business, particularly on awards, given that only less than 5% of small businesses take up enterprise agreements. They rely on awards to provide for terms and conditions for their employees. And if I can just extend my question to your previous one, if there was such an issue around penalty rates that existed insofar as small businesses were concerned, there'd be a massive rush, would there not, of small businesses seeking to enter into enterprise agreements to roll up salary and wages to incorporate penalty rates. There's not.
And it's not happening.
Yes.
Yeah. Thank you.
Senator, if I might also just add to that question on consultation, I would certainly say that we're all part of the NWRCC process and a COIL process, or most of us are. So the government did go through that normal process. I suppose what I would say, and in fact I think went beyond that in some respects, but what I would say is that some of the feedback that we provided throughout that process hasn't made its way into the bill. Some of the concerns that we highlighted at that point didn't make it in. We provided, I think, a range of constructive suggestions, even insofar as having things like a very clear explanatory memorandum, and they haven't been provided in the EM that got published as well. So I think there is a difference between that meaningful consultation and perhaps just having a certain number of meetings.
And obviously providing practical solutions to make the legislation more workable for employers, regardless of their scale, to actually implement.
The role of the Committee on Industrial Legislation really is to look at the technicalities of a draft, but also to highlight any consequences, unintended consequences that may arise. We identified a number of those and suggested ways that they could be dealt with, but they haven't featured in the bill.
They weren't adopted?
No.
Okay.
Yeah, I was going to say we should also acknowledge that there was some engagement with us in relation to the development of the bill. Without going through the detail of that, we also advanced concerns, both substantive concerns around its content, but also about the drafting and perhaps unintended consequences. We acknowledge that some of those concerns were addressed, but one of the issues we've tried to point out is that we think, even with the amendment that was made after the bill's implementation, we still think there are deficiencies in even just the drafting that would have unintended consequences. And we have, take your attention particularly to paragraph 40 of our submissions, proposed some amendments that would go some way to addressing some of those concerns, and which, in our understanding, wouldn't be inconsistent with the objects of the government. They in particular go to ensuring that this amendment doesn't in any way operate as a catalyst to disturbing some of the existing provisions in awards. And we don't understand the intention of the government to be to open the door to that, but we think that that should be put beyond doubt. So, yeah, we would acknowledge some engagement, particularly around the drafting type issues.
And if I may, Senator, just to add on the small business perspective, what we see with this legislation is really that risk of creating a two-tiered system. The role of enterprise bargaining, as we've heard, for small business is simply not practical due to resources or HR capability. And when we look at the fact that 75% of award-reliant retail workers are employed by small and medium businesses, that's not just locking the employers out, it's locking those employees out of the potential benefit they could realise.
And there's a potentially massive power imbalance between a large, powerful union and a small business operator as well, and their employees, I guess.
Yes.
Mr. Schmidt, I have a question for you in relation to your submission. You raised concerns then about the policy intent of this bill and a range of other drafting uncertainties about how it will operate in practice. What do you consider to actually be the real intent behind this bill, and how it will actually play out in workplaces, in smaller businesses and larger businesses as well?
Well, Senator, what I would say is I think that the consequence of the bill, if it's not amended substantially or if it's passed, we say it shouldn't, will be very different to the stated policy intent. I think when you look at the provisions of the bill, it deals with two elements. Obviously, one of those is locking in penalty rates, but the other is the way that the Commission creates substitution terms. The penalty rates element of the bill, that's a hard and fast rule, can't go backwards, restricting the Commission's power. In relation to the substitution of those terms, I suppose we're worried about what that might mean for future flexibility, but also current flexibility. So if we think about where those terms exist in awards, They're things like exemption rates, they're things like salary provisions. The Department of Employment, in its submission, I think, acknowledges there's no definition about exactly what those arrangements might be. That opens the door, as is identified in, I think, Professor Stewart's submission, to cover a range of other things too, including toil provisions, other flexible work arrangements, including potentially an impact on the current proceeding before the Fair Work Commission regarding work from home provisions. Now, when you look at those type of terms and where they exist in modern awards, I would say that that's one of the few remaining bastions where employers and employees have some degree of flexibility to put in place arrangements that suit their own needs without going through some sort of complicated bargaining process or without the intervention of some other third party. I think that these particular provisions are highly used and highly valued by businesses and workplaces and employees because they allow an employee and an employer to sit down and say, let's go and put in place something that's going to suit our needs. It enables business to respond nimbly to changing operational needs. It gives flexibility to workers. It gives certainty to workers, and it's an arrangement that suits their needs. And as I say, there's no complicated process, save and except for either some record-keeping issues and/or the payment of an exemption rate. Now, it's my contention that, for whatever reason, these type of arrangements seem to not really have the approval of the trade union movement. In fact, it seems to me they have a series of problems with these type of arrangements. I get a sense that they are opposed to letting employers just sit down, talk to their employees and put in place arrangements that suit a business needs and suit the needs of workers. And that's what these modern award terms do. So I think that the ramifications here are that not only will it make the inclusion of these terms moving forward much harder, it's going to jeopardise and potentially see these terms removed from awards where they currently exist. What's the consequence of all of that? As some of the unions said this morning, I think the government itself has said, well, if you want to change these arrangements around, you should go and do some enterprise bargaining. As some of my colleagues have already identified, enterprise bargaining is a very complicated, time-consuming, expensive process. The changes under the government made in its last term locks employers into an EBA when it's made. There's a whole raft of administrative hurdles you need to get through, and of course, in practice, it's very difficult to actually have a union or non-union enterprise agreement. Very, very difficult. So with all of that complexity, why would a small business, for example, sit down and say, that's what we're going to do? So I think the end game here is effectively to remove this last remaining bastion of some degree of flexibility, encouraging employers and employees to talk to each other and to come up with something that suits their own needs, subject to a safety net. I think it's all about removing that. I think it's all about forcing employers and business to go down a path of having to negotiate an EBA. That's it. I think that's a very poor outcome, particularly for small business, and would remove, as I say, one of the last remaining bastions of flexibility within modern award terms that doesn't require complication. I think, and I think all employers would agree, that employers and their workers should sit down and should be able to discuss things and come up with things that suit their own needs.
Well, they should be able to, and they should be able to do that without the intervention of a union, but should be able to do it with the support of the union if that's what an employee wants. And that's my concern, is they're not being given that choice, based on what I'm beginning to understand about the implications of this legislation. I then have an interest about what that means for productivity. The Prime Minister and the Treasurer are talking about productivity and their special roundtable, and productivity is a key issue in our country. Do you think that this legislation will have positive or negative impacts on productivity, particularly for small businesses, and how they actually divert their resources away from actually functioning to once again working on administrative and regulatory compliance?
Well, yes, I do, Senator. I think obviously it's going to have a negative impact on productivity. Now, I know there's been a debate about this earlier in proceedings today, but I would simply make this point. If an employer has 30 employees or 15 employees or 5 employees and they are paid an exemption rate salary, each week they get paid once. That's very simple. If all of a sudden the exemption rate didn't exist and all of a sudden you had to take those 5 employees or 15 employees or 30 employees, look at the time and wages records, look at when particular provisions in the award may or may not be triggered, look at when penalty rates may or may not apply, look at whether they've worked overtime hours or not, look at what particular allowances might apply, look at whether there's crib breaks, whether they got minimum time off between shifts, all of these particular provisions, only to come up with an amount which is going to be probably less than what they would get under the exemption rate. So by default, that employer will have to spend a lot of time doing that week in, week out. That time can be easily avoided. Now, might not, have a huge impact on productivity, but it doesn't help productivity. It does help business efficiency, and it helps small business people have more time to spend working in their business rather than on their business.
Okay. Did anyone else want to make a comment on that before I go to my next?
I wouldn't mind jumping in and just, I guess, supporting what Sean has said there. So I think there's a few ways in which we say without that this legislation will harm productivity. I think one is, in the rostering point. So instead of allowing employees to just work when they want and when suits them best, employers will need to go back to very strict rostering rules. And there seems to be, I guess, a view among some parties that compliance with modern awards and the Fair Work Act can just be achieved through the click of a button or a stroke of a pen. It's fundamentally not true, both for small businesses, we heard, but in some ways those problems get exponentially larger and more complex for large organisations as well, particularly when you've got multiple modern awards or enterprise agreements or a combination of both applying across huge workforces, working in different states at different times in significant industries. So it devotes resources away from productive work into compliance, basically, and ensuring that rosters are compliant and affordable with whatever the compliance budget is for the organisation. Time and wage keeping is another compliance drag on organisations that is reduced, not done away with, reduced subject to safeguards by an absorption rate. It allows employees to have consistency around their pay from month to month, which I've heard from others can assist in obtaining finance. It also allows business to let workers work when they want to work, when they are most engaged and they feel they can be most productive around their family circumstance or their personal circumstances, by understanding that subject to these safeguards that apply to the absorption rate, you can allow an employee to work a work pattern that suits them both. And we hear from the union movement that their view that increased engagement will increase productivity. And this is one way to allow the flexibility for enterprise and employees to work together to find out what suits them best. We want workers to get paid more. We want business to do well. And we think that that is achieved, firstly, by lifting productivity, which is the only sustainable way to improve real wages. And secondly, by letting business and their workforce work together without the intervention of a third party or tribunal.
Yeah, I think that's really important. And I think for me that work together piece is something that I discussed with the union movement this morning, that, not all business is bad and not, good faith actors, in trying to get best outcomes for themselves and their employees. And it makes me think about, the current working from home arrangements where a lot of employers are trying to, navigate that and work with their employees, particularly as it relates to job satisfaction. We saw as an outcome of the election as well how important work from home is, and many people prioritise that flexibility over dollars. The AI Group and other parties have actually raised concerns that the proposed bill will interfere with proceedings that the Commission is currently conducting regarding facilitating work from home arrangements. I'd be interested in your comments on that, and if you could explain why these amendments could interfere with those proceedings and impact perhaps people's ability to negotiate work from home arrangements with their employers.
Yeah, sure. For context, the Commission undertook a review of awards last year, and it was at the initiative of the then Minister, or previous Minister, Tony Burke, looking at various things, but including how to simplify awards. Now, after that review, the Commission determined that it would initiate proceedings of its own motion to effectively look at working from home arrangements and essentially look at how we can, or how it can, remove award-derived impediments to employers and employees implementing working from home.
So to make it easier to people.
To make it easier, right? And, we had ventilated various concerns around why the awards are actually a barrier to people implementing the kinds of working from home arrangements they want. And in that context, the Commission, itself has identified effectively that penalty rates loom large. If you think about working from home arrangements, I think everybody realises that, provisions in awards that say, for example, that once you start your working hours at a particular time, you have to work them all continuously and then finish them. And if you work outside of those hours or outside of a certain spread of hours, you get penalty rates. You don't reflect the reality of the way people work now. We know that employees want to take breaks in the day. They want to attend to other matters, pick up their kids, drop their kids off, attend to a myriad of other issues.
Go to the doctor, do whatever.
Go to the doctor and make those hours up, at a time that suits them. But one of the problems is that the way the award works is that if an employer sort of permits that kind of flexible arrangement, they're in breach. Potentially of the award, and also depending on how it's implemented, they may have to pay a penalty to the employee for letting them make those hours up at night. Now, those proceedings are sort of still partly underway. We're due to file our material next week. But one of the issues that's likely to be ventilated is, well, should there be a greater capacity for employees to elect to work in the evening or early in the morning to make up their hours without the employer being saddled with penalty rates?
If that's what the employee chooses to do.
If that's what the employee chooses to do and it's agreed, or should there be some sort of variation to the penalty rate regime? So some sort of modification. Now, we don't know what the Commission has in mind, but the point we make is that this legislation could be a potential barrier to implementing measures that would, assist employees to work from home and also that would insist productivity. So to build on the comments of my previous colleagues, on the productivity point, really what it does, it ties the Commission's hands and it prevents it from implementing changes in awards that would enhance productivity. And in particular, that would remove regulatory burden on employers, particularly around time recording and so forth, which we've said is just frankly unworkable and is a fiction.
And perhaps to that, and I'll have to finish here so the Chair can rotate the call, then it creates perhaps not just a barrier to that, but a mechanism by which an employer goes, actually, it's impossible for me to allow you to work from home. You're going to have to come in because I can't manage X, Y and Z, and I don't want to face a situation where I am penalised for not being able to have oversight of what hours you're actually working at home. So you have to come into the office or whatever the workplace is so I can physically see the hours that you're working.
Because in order to ensure compliance with the award, firstly, some employers may be reluctant to agree to some flexible arrangements that people have when working from home and won't let them work the way they want or let them work at home. The next issue is that record keeping requirement. The reality is at the moment that awards contain very onerous requirements where people are paid an annualised salary or an annualised wage arrangement, it's called, to record starting and finishing times, all the hours of work. Now we know, and research that's been commissioned by the Commission validates this, that in reality that's not happening, that many employers don't have visibility over the precise hours, and of course many employees resent sort of intrusive monitoring of their hours, and you see unions routinely opposing that. The point we're raising is that this sort of amendment is going to prohibit various sort of mechanisms being implemented by the Commission to get to address those problems, frankly the unworkable element around record keeping, but also to encourage working from home. It will remove the Commission's ability to come up with various types of arrangements that would facilitate working from home.
So negatively impacting the flexibility and negatively impacting productivity.
It would negatively impact productivity or prevent the Commission from improving productivity. It would prevent the Commission from making sensible changes to our notoriously complex awards to remove some of the regulatory burden on employers, and it would foreseeably prevent the Commission implementing substitution terms, if you will, to use the words of the Act, that might facilitate working from home arrangements that both parties want or are agreeable to.
Okay, thank you. Thank you, Chair.
Thanks, Senator Vasic. Senator De Lega.
Thanks very much, Chair. Excuse me. And thanks to the business unions for coming along today. I really appreciate your contributions so far. Today, the committee has heard lots of evidence from workers and their unions who rely on penalty rates, and they've spoken about some of the sacrifices that they do make for their work in exchange for their penalty rates. Just wanted to ask then, do you guys agree that workers should receive penalty rates and overtime rates when they work unsociable hours? Yeah, just a broad question for everyone.
Yes, I'm happy. Thank you for the question, Senator. As I stated in my opening, there's a very appropriate role for penalty rates to play. We've heard throughout our case specifically that some of what we've put forward with the exemption rate has been misrepresented, and for clarity, it does not apply to those level 1, 2, 3 employees, but those on higher salaries and managerial positions that are obviously accommodated effectively and appropriately with those safeguards that I spoke about.
And Senator, I'll add to that by saying that I think everybody here would recognise that penalty rates and overtime rates have been a feature of the workplace relations system for a long time. It's not about removing those penalty rates. It's about taking a more flexible approach as to how those penalty rates apply. As my other colleagues confirmed earlier, there's no application on foot at the moment that we're aware of that will have the effect of removing a penalty rate in any modern award term.
Yeah, we would accept that penalty rates are, of course, an important feature of the safety net. I think the situation, though, is in reality more nuanced than the question might suggest. For example, what we've identified is that there are some circumstances where a different sort of remuneration regime should apply to the standard sort of penalty rate regime. There are circumstances where annualised salary arrangements should apply. If I think back to the Commission's own consideration of this issue in a recent case concerning the Professional Employees Award, where it accepted, in the context of professional employees and I think from memory managers, but I may be mistaken on that, that industrially there isn't merit in applying the same penalty rate overtime sort of regime as would apply to other categories of workers. That's in part why we've said that in some contexts an exemption rate type approach applies, not one that delivers low salary. In fact, our intention is to make it easier for employers to pay people well, but to pay them differently, particularly where they have significant control over the hours they work, the autonomy, where they're paid to do a job, not just according to sort of Bundy clock or specific hours. So, we certainly believe that penalty rates are a crucial feature of the safety net, but it is our view that the Commission should have discretion to work out how and when they apply, rather than just sort of systematically assuming that they apply blanketly to all employees in the same way.
Thanks. Thanks, Ms. Seaper.
Yes, we would definitely accept that there is a place for penalty and overtime rates. I would echo the comments of my friends that there is no application on to reduce penalty rates. I think one thing that gets lost with the absorption rates is that they are proposing, in order for an absorption rate to be applied, assuming that the Fair Work Commission thought it was appropriate in any of the applications before it to include new ones in awards, is that there's a lift to the employee's base rate of pay consistently. So they range from, I think, 25% to 55% above award rates in the applications before the Commission. And I would echo Brent's comments that, employees are increasingly seeking new ways of working. We are increasingly seeing employees say that work from home or other flexible working arrangements to balance work-life commitments are important. We also continuously see a pushback on workplace surveillance and kind of abilities employers have to ensure compliance with time and wage record-keeping requirements in both the Act and industrial instruments like awards. And so they're, annualised salaries or absorption rates that absorb penalties and overtime into a higher base rate of pay are one way of addressing those things that senior and managerial employees constantly say are important to them and that they want.
Thanks, Senator. Small businesses offer services that incorporate services to customers over an expanded range of hours. As I've already said, they rely on modern awards in order to justify the terms and conditions for their employees, quite rightly, and part of those modern awards invariably incorporate penalty rates. So it stands to reason and it follows that small business has no issue with the payment of penalty rates at all. What small business is supportive of is the ability for flexibility to remain with the independent umpire through the approval processes and meeting the Better Off Overall test for different arrangements to be made where it suits both parties and it meets that test.
Thanks. And just following on about the you about what you're saying, Ms. Ether, about the greater flexibility and things like that. But I'm not quite sure if you got to hear some of the evidence from the people who were here this morning. But if we're listening to the cleaners and the Coles and the office works workers, that's sort of not really available. Some of those extra things to them, they've got to do those work in those roles at those particular times. So the importance of that penalty rates makes to them can be the difference of having $100 to pay for their food and expenses for their pay period, So, yeah.
Can I suggest a couple of things in response to those comments? One, again, so this would not be just taking the penalty rates away. It would be absorbing the penalty rates into a higher base rate of pay. And I think we heard from Ryan at the ARA today that their modelling based on the SDA's rosters are that the vast majority of employees would be thousands of dollars better off under an absorption rate than a base rate plus penalty and overtime basis. I think, second of all, the applications aren't targeted at cleaners or perhaps kind of the checkout staff at Officeworks and the like. They are targeted at managerial and more senior employees in the case of the retail application. And thirdly, that one of the safeguards put in place, at least in respect of the ARA's application, which is targeted at the retail industry, is that it will only apply if an employee agrees in writing to the application. So no one is going to be forced into these applications against their will.
Thanks. And so I might just follow up with that to Mr. Swenson. In the submission to the retail award variation case, the SDA produced evidence of members who would be more than $1,000 worse off each year, and model rosters that would be more than $5,000 worse off each year under the proposed exemption rate. What's the ARA's reasoning for wanting to cut the take-home pay for some of those retail workers, like under that monitoring?
Thank you, Senator. And with respect, we would reject the notion of that question because our proposal doesn't do such a thing. In the first instance, as we've heard, this is really targeting those higher level employees, and it is about opt-in, so it's all about choice. Through the Fair Work Commission, we've engaged very constructively to design the appropriate safeguards that mean workers that don't choose to opt in at that high rate won't. If I can point to just one example of how this would look in practice, again based on the SDA's modelling, there's an employee that works full-time at level 6, currently averages 41 hours per week, and that includes 3 hours of overtime and an average of 2 weekend days per fortnight. Under the GRIA rules, they would receive $69,038, but with the 35% exemption rate, they would receive at least $76,000, which is an improvement of $7,500, providing them that consistency and again that choice to opt in.
Thank you for that. I might just follow up on my other question, just about the first one was about the the accepting the workers giving up and working social hours in exchange for penalty rates. And does anybody know how long that they've formed part of the minimum safety net in Australia?
I'm certainly not sure for exactly how long, but they've obviously been a long entrenched part of the system, as have exemption rates, I might add. They've also been historically a prevalent part of the safety net for a very long time. I think, if I may also just answer the questions you raised around, I suppose, the impact on people falling from the applications. I think I would just urge the committee to be mindful that they are applications, that the way the Commission works is that an application is advanced, there will then be evidence about its impact, and the circumstances of workers in particular industries will then be carefully weighed as to whether they should be granted. But importantly, the Commission isn't bound to grant the application in the terms we're asked for. The Commission can determine that there are additional safeguards or modifications to the application that should be made. And that's the, a key point why the Commission should retain discretion over these issues, rather than there being a knee-jerk legislative response to applications that are on and that haven't been fully determined by the Commission, because it can work through all of those issues and then work out whether there should be additional flexibility and what safeguards should be there.
And Mr. Ferguson, I might follow up, and anybody else if they'd like to contribute. Will these laws change any existing obligations that on employers regarding the payment of penalty rates and overtime rates under the awards?
It won't. Well, the laws, well, they may. So I think the point here is that's the technical issue we've raised. You know, the government, I think, is clear that its intention is to only restrict further variations being made to awards. But the point that we've raised, and Professor Stewart has actually raised it quite succinctly as well, that the way the legislation has actually been framed, and particularly the provision going to substitution terms, for example, if a party seeks a variation to the award, and I think it might be the ASU, but my colleagues will correct me if I'm wrong, has indicated that they're going to seek variations to align current award terms with these new principles. The way it has been drafted, we think will require the Commission, when assessing that application, to potentially bring existing awards into conformity with these principles, and that they will, as a result, potentially remove long-standing flexibilities in awards that are working for the benefits of employees and employers. I think the Professor points to even the annualised salary provisions and so forth, the toil provisions, as Mr Schmidtke has referred to. So I don't think the bill was intended to disturb existing arrangements, but there is a very real risk it will, and this committee should recommend, in our view, that careful attention be paid to the drafting and that there be amendments to avoid that, or that certainly put any risk of that beyond doubt.
And Senator, if I could just add to Mr Ferguson's comments, but perhaps slightly disagree with him on one element. I think the drafting of the bill is intentional in terms of opening the door to change existing provisions. I think there is a very real risk that that will occur in the future, and employers that currently use those provisions are in jeopardy of losing them, as are employees, importantly. So I do think there will be, perhaps not on the day if this bill passes, will be an immediate effect that day, but certainly in the future there will undoubtedly be an effect, and it won't be a positive effect for employers. It'll be a much more time-consuming process.
Some of the overwhelming evidence today was that's been given so far was about the maintaining the status quo. So you're saying that that's different, like that the current laws would not maintain the status quo for businesses currently. It's just protecting what there is.
I think the point we're making is that the approach to the drafting, and I think Mr Schmidtke goes further than me, but that could be a catalyst for changes to the status quo being made by the Commission. Obviously, it's dependent on something being done by the Commission, but the concern is that will compel them to. The big concern in terms of the change for the status quo is, at the moment, the framework of the Act lets the Commission modify awards to address changing circumstances. And to update them, if you will, to change the penalty rates, but also it creates an avenue for parties to deal with problems, such as the fact that at the moment there is a notorious problem around the record-keeping requirements and the annualised wage provisions being unworkable and, frankly, not complied with. And at the moment, the status quo is that people have an avenue for going to the Commission and constructively proposing an alternate mechanism to address that. And that's what we've tried to practically do in a very targeted way through the exemption rates, is to provide a workable solution to a known problem. The change to the status quo is that right for employers and for unions and for everyone will be removed, because the Commission won't have to apply some principle, as I think the ARA has put. It's just going to be an absolute prohibition on the Commission making these changes, even if it sees them as merited.
And if businesses are already complying with the current award system, what would they need to do differently when the bill comes into effect?
Well, I don't think they are necessarily complying with the award system. I mean, I look at the evidence that the Commission has commissioned through its survey of employers in relation to the working from home case. The suggestion in the material from surveyed employers and employees is that employers have no visibility over working hours for many, I think for the vast majority of their workers. It raises the proposition that there is frankly an air of unreality around the provisions in some of those awards, those very common model provisions that were inserted just before the pandemic. And it demonstrates that they frankly clearly won't work where people are working from home, a development that occurred after those provisions were inserted into the award. So I don't think we can rest on the assumption that everything's working swimmingly in the award system. It's notoriously problematic. What this bill is going to do is stop those problems actually being fixed by the Commission in the ordinary way, and the way the Commission is doing. It's going to stop it doing even when the Commission, of its own motion, identifies that there's a problem that should be fixed. And that's what one of the proposals we have said is that there should be an exemption that allows the Commission itself to retain an ability to commence proceedings and to make variations to awards, provided they're fair to employees, but where they're flowing from its own initiative to address a problem. That would certainly not open the door to employers making claims, but would provide some sensible avenue for addressing the known problems that are otherwise just going ignored, frankly.
And Senator, to answer your specific question, if the bill takes effect on that day, there won't be a change. But what there will be is that risk, as I've outlined before, that future or existing arrangements, for example, the use of salaries or exemption rates, may not be able to apply in the future. And again, that's a real risk for employers and productivity, but it's also a risk for employees, wage certainty, their flexibility and their stability as well.
Thanks very much. Thanks, Chair.
Thank you, Senator Delega. Happy?
I've got a couple more questions, if that's all
Sure.
right. Yeah, perfect. Excellent. Thank you. I've been thinking through as each of you have been speaking, and it sort of raises a couple more questions for me. And primarily, it's in relation to the record-keeping stuff. And I think it was Professor Wright made the comment around burdens from record keeping, could be accounted for by, technology, computer systems, all the rest, and, they should be pretty simple. And Ms. Ether, I note you speaking before about the fact that it's not just a push of the button type of solution for this, that this is an ongoing compliance and administrative requirement, and I would call it a burden. What is the real and genuine impact to businesses around this in terms of whether they actually choose to employ people? Will this be actually a barrier not just to productivity, as we spoke about, and to flexibility, but to employment? Do you actually go, well, it's too complicated to hire people, where these rates or these processes might apply, and we're just better off not doing that at all?
Look, I think probably the margins that could be an issue, but I can say in terms of regulatory burden, it is just enormous, and it is huge for small business that may not have dedicated, not just HR, but payroll expertise, because they are two separate disciplines. While there are a number of very good kind of time and attendance and HRIS systems out there, I think there's very few that are completely, could say they're completely compliant with all modern awards, certainly not with enterprise agreements, which are bespoke instruments and will have all of their own kind of time and attendance rules. Long service leave that changes from state to state and industry to industry in some cases. And so this regulatory burden, which is huge for small business but enormous for large business, will not be resolved. And to the extent that there is technology that can track when employees are working and ensuring that they are taking all of their breaks in accordance with the award, and ensuring that they are not working excessive hours or outside of rostered periods that have been budgeted for or assigned, they are often pushed back really hard by unions. So anything that has a biometric element that can kind of track time and attendance in the workplace is often pushed back on. But certainly processes that attract people's work online, which is really realistically one of the only ways to check when people are working and to record as required by law when people are working from home. We see significant resistance to that. We've seen that through a number of public statements from the union movement. We've seen that through the recent Victorian inquiry into workplace surveillance. And so there's no kind of give and take, and employers are left in this really invidious position where employees want to work as they want to do, which employers might be happy to allow certainly if people are employed to, I guess, achieve an outcome or do a job as opposed on an hour by hour basis, but left with no manageable way to meet their record keeping requirements at law, and left carrying the burden of, additional penalty rates and overtime when they might not have asked or required an employee to work at those times. They were trying to facilitate it to meet the employee's personal
and to keep their employee and to keep a good relationship with their employee.
And that's right. And I shouldn't say burden in the sense that employees are not happy to pay those things. They want to absorb them into a flat and consistent hourly rate of pay, subject to certain safeguards. So at least, you know, in all of the applications, once employees are working over certain numbers of hours, overtime will again kick in as well.
This is a question for both the larger employer groups and for COSBOA. Have you guys done any modelling on as to the costs and impacts of this on your members or on, you know, employment, you know, shifts in employment reductions as a result of this for your members as well?
The last State of Small Business report that was commissioned by COSBOA Senator last year identified that the average small business person was spending 15 hours per week on average dealing with the complexity, admittedly not just in Fair Work regulations, but in regulations generally, to manage their small business. So I've used the example of a cafe owner who employs 5 people spending 15 hours a week is a enormous impost on the ability of that cafe owner to manage and grow their business. We make the point that small business wants to be compliant. None of the members of our peak organisation, do not want to be compliant with legislation. It's the complexity of the requirements of compliance that's the issue. So this legislation proposes further complexity, further restrictions on the ability to be flexible, and we would argue that it's impacting the ability, and we do have evidence that I'm happy to provide to the committee at a later time, that small businesses are actively making decisions to maintain employment levels below the threshold as contained within the Fair Work Act of 15 or less headcount employees. So that is actively happening. They get limited benefits for retaining the definition of being a small business under the Fair Work Act, but they are actively making decisions on account of the increased compliance and record-keeping requirements to keep their employment levels below 15, and that has obvious impacts on productivity and employment within the economy.
Sorry, Mr. Ferguson.
I can't point you to any specific sort of survey evidence in terms of, you know, analysis of the absolute costs that would impose. But what I can say is this: that the record-keeping obligations that are the controversy that have been the catalyst for the exemption rate cases partly arose from a decision, or did arise from a decision just before the pandemic to insert record-keeping obligations in awards for people paid an annualised salary, put simply. When that decision was handed down, it caused enormous controversy in industry. I would say that was probably the biggest industrial controversy that we were dealing with just before the pandemic started, because people were responding to the fact that how are we going to keep all of these records and so forth, particularly for people that are paid to do a job, they're paid a salary, they're not sort of paid by a Bundy clock, and they control their hours, they're not monitored, they're trusted, it's a cooperative relationship. How are we going to do this? You know, I've heard employer after employer tell me that the workers won't comply. They won't keep the records even if we ask them. And of course, after that decision, the world changed and working from home grew exponentially. Now, I haven't heard the evidence this morning of Professor Wright, but I very much doubt the proposition that all employers are out there with technology in place, with complete oversight of the exact working hours being performed by everyone when they're working from home. And that's not what the Commission survey evidence indicates. And it also indicates that a vast majority, I think it was in the 90s, if not 98% of people are attending to personal things during working hours. As I said, there is an air of unreality about the assumptions in our award system around how records are kept, particularly for high-paid senior employees with a degree of control and autonomy over their hours. And the point, if I bring it back to this bill, is this bill will stop, or at least make it harder for the Commission to implement alternate remuneration provisions and clauses to go some way towards addressing that issue, at least make it more difficult.
Yeah, and I guess that's the challenge. The other thing that I wanted to ask you about, and you made the comment about interpretation of the bill. This morning, the union movement made the comment, I think it was the ACTU, that it's a pretty simple bill. In some questioning from Senator Pocock, one of the answers was, oh, well, that's a very literal reading. In our own reading, we see it this way. Do you see grey areas here? Do you see there being confusion around this and what kind of problems that might create?
Yes, Senator, absolutely. There's a significant number of areas where the draft bill lacks, I suppose, technical specificity to put in place what the government suggests it's putting in place here. One of the questions I think that arose this morning was whether or not somebody agreed that a recent amendment made on the 31st of July would have the effect of not requiring the Fair Work Commission to undertake a review of all modern awards. Yes, that's right. The witness said, yep, that's what the legislation says. What it doesn't do is it doesn't prevent the Fair Work Commission from undertaking that review if it decides. There's a whole raft of other areas about what is defined as a substitution term. I'm sure the department will be here. I'm sure they will be able to highlight that element themselves. Again, why not have that clarity? The explanatory memorandum, I think, the supplementary explanatory memorandum talks about really this provision only being enlivened upon application. That's not what the amendment actually says that EM relates to. In fact, it's a very, very broad description within the bill. So it lacks all of that. That's why I think what does it mean in terms of things like work from home and span of hours? If it's not intended to impinge upon that, make it clear.
Yeah, say so.
Yeah, but it's not there as it currently stands. And the fact that we've told the government about this, we've raised concerns not only here, not only in our submissions, but even in when the bill was first introduced, and they remain unaddressed, does make us think, it makes me think in particular, that there is a genuine, determined purpose and intended outcome here, and the door's left wide open for that outcome.
Could just Mr. Ferguson finish and then I'll ask.
Yeah, sure. I think a couple of questions as well.
Of course. Look, I think it seems pretty inevitable that we're going to spend a lot of time arguing around the interpretation of these provisions and what impact they have in the context of different applications.
And that's the last thing we need.
Well, I've spent much of my career arguing over award clauses. It's the last thing we need is another complex element of our workplace relations system. But I mean, just to provide an example, put it in sharp focus, I mean, I think that properly understood, the provision modifies the Commission's ability to change the rate of the penalty rate. But I saw some conjecture in the submissions that perhaps it changes the circumstances of when a penalty rate can apply. Now that is not in contemplation as we read it, but others are reading it that way. And then there is this big issue that's looming large about, is it only stopping the Commission from granting new proposed variations, or is it going to in some way cause them to disturb existing arrangements? To echo Mr Schmicky's point, why not just put it beyond doubt?
Yeah. Thank you.
Thanks, Senator. I just wanted to clarify a couple of things, and maybe this does come down to a question of interpretation, and I'll put the same questions to the department as well. But we've heard evidence on this panel that the bill will prevent employers and employees doing that direct engagement, facilitating and negotiating flexible arrangements. But that's not accurate in my reading of the bill, so I'm asking you if you could point to the section of the bill which does that. And also, we've heard evidence from you that the bill will prevent exemption rates from being included in awards. I don't believe that's accurate either, and it's contrary to evidence we heard earlier this morning. Simply, the bill requires the rate to be high enough to fairly compensate employees for the penalty and overtime rates that they would otherwise be exempted from. So if you could clarify the first one, where it is in the bill that takes place, so we can put it to the department, and also on the second.
Yeah, well, I don't think I put that first proposition to you or to the committee, but I think properly understood what it would do.
Sorry, that was my interpretation.
Oh, no,
earlier.
Yeah, but I think what I think where it would hamper it is it would stop the Commission from implementing clauses that rely upon a level of agreement or cooperation. I'm sorry if I'm misremembering your exact phrasing. But so, for an example, it would prevent a working from home term going into award potentially if it had an effect which was contrary to paragraph B, in that it was a substitute term and that it had some resulted reduction in remuneration.
Well, it wasn't fairly compensated for.
well, if it resulted in a reduction, to use the of the additional remuneration as framed. Now, I mean, I suppose it doesn't, we're not saying for our part that it alters the possibility of agreements being struck outside of the award or in any way in the usual way. And that's, of course, that can happen. That can happen through agreement making. It's really just limiting arrangements that can be put into awards that facilitate cooperation and agreed alternate arrangements, if that makes sense.
I think we'll put this to the department, both of those points as well, because anyway, I think there's been a sense of contradictory evidence presented to us today.
Yes. I think our submission deals with this issue, though. It actually creates an incredible obligation on the Fair Work Commission, and I'll take you through the wording, to ensure that the two outcomes contemplated in the substantive part of the bill are not achieved. So if you look at section 135A, subsection 1, in exercising its powers under this part to make, vary or revoke modern awards, the Fair Work Commission must ensure that the outcomes in A and B are not triggered. So that doesn't include terms that substitute employees' entitlements to receive penalty rates. It goes on. Now, it doesn't require the Commission just to be satisfied that this won't happen. It doesn't require it to put in charge appropriate safeguards to minimise that risk. It's an absolute obligation to ensure that that just will never happen. Now, and if it doesn't achieve that outcome, there's a real risk that the Commission hasn't properly discharged its obligation or it's acted beyond power. Now that, in our view, is likely to result in the Commission taking a very conservative approach to the weighing of applications to insert the types of exemption rates, for example, that we've proposed, and that will weigh very heavily against the prospects of getting one up. And as others, I think, have pointed out, it's reducing the additional entitlements for any employee. It's going to run the risk that people are going to have to be speculating about the potential impact on every single worker covered by an award. That's an incredible task. Now, we think that's frankly going to be a significant barrier to people getting proposals to vary awards to fix some of the problems I've talked about successfully implemented. And so we, again, paragraph 40, we've identified some modest proposals that moderate that a little bit. Frankly, they don't go far enough to warrant the passage of the bill, but we think that there should be a softening of that issue. That's as far as I can take that.
And Senator, just on the first question that you asked, likewise our submission at paragraphs 33 to 50 go through this in quite some detail to explain how the uncertainty arises. But in short, it's to do with the application of proposed section 127 and its conjunction, when read in conjunction with 135A1, then associate that with the lack of specificity in as defining substitution terms in 135A1B. The concern arises also because of subsection 2, which creates an very clear express provision that says that the provision doesn't limit the Commission's operation with respect only to those particular provisions, but not any other provision under Part 2.3. And of course, as I alluded to before, the amendment of the 31st of July, subsection 3, basically says nothing requires the Commission to do a particular thing, but at the same time it does not prevent the Commission from doing that if it so desires.
Thank you. I mean, I appreciate where you're coming from, but look, we'll put these questions to the department as well this afternoon, and maybe that will provide helpful clarity to all. I just have one final question for you, and it's probably one for you, Mr. Ferguson. But say this bill passes the Senate Tuesday, 2 weeks' time. On Wednesday morning, what obligations have changed for an employer when it comes to penalty rates and the payment of overtime?
So on Wednesday morning, no obligations change in relation to those issues. The capacity of parties to seek variations to awards will change, will be reduced. And of course, it may well be that this is a catalyst for parties to make applications to change entitlements. Again, I think one of the union's parties made it very clear, I think it was the ASU, that they were intending to make applications to address existing award provisions to align them with these provisions. So clearly some unions intend to utilise these amendments to attack existing flexibilities within the award system and to, by extension, create new obligations for employers. But to your question, on that day, I don't understand this bill to change on that day, the entitlements or obligations that the awards would provide.
No, but I mean, I think what we've heard this morning for many workers around the country have felt a degree of anxiety around, the protection of their penalty rates and their overtime rates, which they rely on. It gives a degree of incredible comfort for them after a long, long period of uncertainty where they felt like those have been at threat and under attack.
But I just don't know why they think that they've been at threat or under attack prior to the introduction of this bill, because as I've said to you, there is no application on foot that's seeking to reduce the rates of penalty rates. I mean, this just evolved in the election campaign. There wasn't proceedings where people are trying to reduce the quantum, but I can't speak to the anxiety that people may have felt this morning about that. But I think, as I've said, people should understand there are very significant protections in the Fair Work Act. The Commission, the independent umpire, is required to ensure a safety net of fair and relevant minimum standards. And that is the ultimate protection. Of course, it was implemented by a previous Labor government and it stood the test of time. And then that protection was built upon by amendments that specifically require the Commission to take into account the need to provide additional remuneration for employees working overtime, working weekends, working unsociable hours, and working shifts and so forth. That adds extra protection. So I don't think there should be that anxiety. I think people are needlessly worried. What our applications are trying to do is implement beneficial arrangements that actually make it easier for paid people well and to give people the kinds of flexibilities that we know so many employees want to continue to enjoy.
All right, Mr Ferguson, look, we really do appreciate all of your engagement with our committee, the time you've taken to provide submissions and also to be here with us today. We do appreciate it. So thank you again. I don't believe there are any questions on notice. Yes, but look, if you did take them or are to take them, we need them back in 2 days, so on Friday. It's a very short time to phone. But I don't think you took any, so it shouldn't apply for you. But thank you, you're dismissed, and I'm sure we'll see you at another hearing soon.
Thanks very much.
And I'll be calling our departmental officials to the table. Everybody. It is wonderful to have representatives from the Department of Employment and Workplace Relations with us. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of that order is available from the Secretariat. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, can I ask each of you to please state your full names and the capacity in which you're appearing today? We're just going to go from this direction to that direction, so Ms Chong will start with you.
Hello, my name is Ariel Chong. I am an Acting Assistant Secretary in Workplace Relations Legal in the Department of Employment and Workplace Relations.
Sarah Godden, Chief Counsel and First Assistant Secretary, Workplace Relations Legal, Department of Employment and Workplace Relations.
Diab Harb, First Assistant Secretary of Employment Conditions Division at the Department of Employment and Workplace Relations.
Tara Williams, Assistant Secretary, Safety Net Branch at the Department of Employment and Workplace Relations.
Thank you and welcome to you all. Does anyone have an opening statement they'd like to make this afternoon?
Thank you, Chair. The Department does not have an opening statement, so we're happy to proceed straight to questions.
Wonderful. I'm going to go to my colleague online, Senator Mulholland. Senator, you have the call.
Thank you, Chair, and thank you to the Department for joining the committee today. My apologies for joining you remotely. If you do miss anything I say today, please feel free to get me to repeat it. On behalf of the committee, I'd like to say thank you for your detailed submission to the inquiry. I'd like to firstly just go to some of the detail around the Australian workforce, in particular, how many Australian workers are reliant on the award safety net. And I'm happy for whoever relevant to jump in.
Sure, Senator. I'm happy to take that question. So there's 2.6 million award-reliant employees that rely on modern awards in the national employment system. Of those award-reliant employees, they are more likely to be women, so almost 60% of them are women. They're also more likely to be under the age of 35, so about 57% of them are under the age of 35. They're also more likely to work part-time, so 67% of them work part-time, and they're also more likely to be employed on a casual basis, so 48.3% of award-reliant employees are employed on a casual basis as compared to 21.3% of all Australian employees. The other thing to know is that approximately 20.3% of all workers are paid at the minimum wage rates in the 121 industry and occupational modern awards. So that's the award cohort overall.
Thank you. So, as is detailed, obviously a fairly vulnerable cohort of workers that we're dealing with here who are reliant on awards. Can you also just talk me through some of the key characteristics for workers who may be dependent specifically on the retail award?
Certainly, Senator. So on the retail award, there's approximately 353,000 workers that are relying on that award, and that's actually the highest award reliance in the modern award system, so 12.1% of award reliant workers. And of those, I think we see again 29.5% of these employees 29.5% of all retail workers are award reliant, and of these, 2/3 of them are women. Again, a bit more higher than the general cohort, so 78.5% work part-time, and again we see a higher incidence of casual employment of award reliant retail workers at 61.4%.
Thank you for that. I just want to now go to some of the history around penalty rates. We've heard a little bit of discussion about this earlier evidence. How long have penalty rates and overtime rates been a feature of Australia's award safety net?
Senator, and I should say thank you to the team back at the department who is listening hard to us, but they've actually been probably a feature, I would say, like testing my knowledge here, but since the kind of system as we know it with the Commonwealth and Conciliation and Arbitration Commission began in 1919, and that's when we first saw Sunday penalty rates for working unsociable hours come into place. And then over time, they expanded that, I think, to weekend work overall, which in the benchmark in 1947, which is the Metal Trades Award, which forms the kind of benchmark award for the modern award system overall. So that was in 1947, and that's when It provided for a Saturday penalty rate of time and a quarter, so 125%, and increased the Sunday penalty rates to double time of 200%. I could kind of keep talking you through the long history, but I guess what I would say is part of the award modernisation process that occurred at the start of the Fair Work Act in 2009, and then modern awards commenced in 2010, and there was a consolidation, I think, of over 3,000 pre-reform instruments into the simplified 122, as it was then, modern awards. That's when we saw, I guess, a consistency of penalty rates across the modern awards system.
Thank you, much appreciated. What would also be helpful is just to go to the role of award safety nets compared to enterprise agreements as well.
Sure. Happy for me to... Okay, I'll take that question. So I guess the system's kind of predicated, Senator, I would say, on 3 levels, and we have a legislated national employment standards, and these are in the legislation, and they go to things like leave, reasonable hours of work, flexible work, redundancy, and these are inviolable standards. All employees must be paid those rates. And then the Fair Work Commission has as task to, I guess, set a safety net on an industry and occupational basis, and that's to go to terms and conditions that supplement the NES, that provide appropriate protections for the workers in that system. And we like to think about that as, I guess, a floor of minimum standards. And then on top of that, where employers and employees want flexibility and arrangements that are tailored to their workplace, they can use the enterprise bargaining system. And what that does is uses the modern award, but then you are able to tailor that to suit the circumstances of your workplace. And that's governed by a test that the Fair Work Commission does called the Better Off Overall test. So that's generally the 3 layers of protections, I guess, in the system.
Thank you for that. So we have heard some evidence today from industry groups that this bill could hinder flexibility and productivity by putting existing entitlements into law. So for the benefit of the committee, could you outline some of the ways in which employers can pursue flexibility and productivity improvements in their workplace?
Senator Sarah Godden, Chief Counsel, First Assistant Secretary speaking. One of the key ways that employers can pursue productivity and flexibility is the enterprise bargaining system. Overwhelmingly with enterprise bargaining, employers use the single enterprise agreement system. So this is where an employer negotiates with all or a cohort of its employees. That can be done entirely by consent if all of the parties agree. There are other ways to initiate that bargaining process, but when bargaining, while the award system operates as a floor, as Ms Williams has explained, there is greater flexibility to come to appropriate terms and conditions for that either workforce or that cohort of the employer's employees, that as long as it results in the employees being better off overall as a global assessment, then that bargain is scrutinised or approved by the Fair Work Commission and can then be put in place to set those terms and conditions. So the bargaining system is how an employer can look at, for example, an award and say, well, these terms and conditions don't really work for my workplace. They can then go and negotiate with their employees to come up with the terms and conditions that really suit their workplace. Obviously, it's a negotiation, so employees might look at some aspects of the award and say, well, that doesn't suit me, or I'm looking for these trade-offs, but it's very much in that process of negotiation and trading off that those productivity benefits or flexibilities can be obtained within that enterprise bargaining system. There are some other flexibilities built into the system. Obviously, there is ability for employers to enter into individual employment contracts with their employees. They can enter into individual flexibility arrangements with their employees, either based on an enterprise bargain or based on a modern award. But they're broadly the categories where employers can pursue flexibility and employees can pursue flexibility as well, or productivity gains.
Thank you for that. I just want to sort of circle back on that. So is there anything in the bill that stops workers and employers talking directly, sort of as it has been suggested a bit earlier today in some of the evidence we've heard? Just, if you could clarify for the committee if there are any provisions in this bill that would stop workers and employers engaging directly to discuss and agree on flexible working arrangements as they already do now and currently exist.
No, Senator.
Okay, thank you. It has also been suggested today that the bill would prevent exemption rates being included in awards. Is there anything in the bill that would prevent that?
Not outright, Senator. So, as I understand it, employees and employers pursue exemption rates because employers are looking for a simpler framework to apply to pay their employees. And they say that there are significant, or as I understand the arguments, they say there are significant benefits to them in terms of streamlining their payroll systems and their payment practices. So nothing in this bill would prevent an exemption rate being put in place, provided that it meets the requirements of the new Section 135 capital A. So if the exemption rate does not reduce the additional remuneration that an employee would be entitled to under the modern award objective 1DA, then that exemption rate is absolutely permitted under that bill. And if there are sufficient benefits in streamlining that payroll system or other reasons why that exemption rate is attractive, then you would expect that an exemption rate might be able to be agreed upon or otherwise brought to the Commission and argued, provided that the evidence shows that it passes that test in 1B. There's nothing to stop that exemption rate being put in an award.
Thank you. I'll just check in with the chair to see how I'm travelling for time.
Yeah, you're all right, and then we'll rotate soon, but keep going, Senator.
Okay, thank you. So I just also want to touch on, particularly in the retail award application to the Commission that we've heard some discussion about today. Can you detail for the committee why it was that the Minister intervened into that application and what the arguments were made? What arguments were made?
Certainly, Senator.
I'm happy to start, Tara Williams, Senator. So I guess the former Minister Watt's submission really went to 4 principles, and I think they're referenced in our submission, I think on page 4 and in the Minister's intervention. I think it's paragraph 6C, but what the 4 principles were that the wages of low-paid workers would not go backwards. So I think I've given some evidence earlier that award-reliant workers and their vulnerability, that the modern awards objective is crucial in sectors that are low-paid, female-dominated and award-reliant, that penalty rates and overtime rates are essential features of the modern awards safety net, and that enterprise bargaining is the appropriate place for trade-offs and negotiations, noting that it's subject to the better off overall test and tailored to workplaces.
And you can find that material on page 4 of the department's submission, Senator, if that assists.
Thank you. That's very helpful. I just also want to, I suppose, just cover off on the consultation that has occurred. So I know you do talk about this in your submission, that there has been some fairly detailed consultation with stakeholders, but if you could step us through the type of engagement and consultation you've undertaken, that would be greatly appreciated.
Certainly, Senator. I might kick off at a high level and then pass to my colleagues to add further details. So The department consulted with a range of stakeholders according to our usual processes, but I might start with going back a step, and that's on the 3rd of June 2025. The Minister convened a meeting of a body called the National Workplace Relations Consultative Council, or the NWRCC. And at that meeting, the Minister foreshadowed implementation of the government's penalty rate selection commitment as a priority and indicated the government's intention to introduce legislation as soon as possible following the resumption of Parliament. The National Workplace Relations Consultative Council has a mix of employee and employer representatives on it, and there are usually a number of invited bodies to that as well. I can go through that membership if that would assist.
Yes, please, that'd be great.
Thank you.
I can jump in here on the membership if that's helpful. So the membership for the National Workplace Relations Consultative Council is set under the legislation for the council, and it consists of 15 members. Firstly, the Minister, who's the chairperson of the council, and then it attempts to create equal representation between employee and employer groups. So 7 members are nominated by the Australian Council of Trade Unions, 3 members are nominated by the Australian Chamber of Commerce and Industry, 1 member from the Business Council of Australia, 1 from the Australian Industry Group, 1 member nominated by the National Farmers Federation, and 1 from the Master Builders Australia. I should also add that the Minister also provides additional invitees to join in the council, and the COSBOA, the Council of Small Business, is also invited to that.
The Minister also advised at that meeting, Senator, that the department was on track to consult with the Committee on Industrial Legislation in early July on that draft legislation. That committee is generally referred to us by us as COIL. I'm sorry if that's an inaccessible acronym. We'll try and remember to spell it out. But it is, in essence, a subcommittee of the National Workplace Relations Consultative Council, which has the purpose of facilitating confidential, detailed consultation on potential workplace relations law reform. Alongside the NWRCC members, as my colleague Mr Harb has indicated, COSBOA is also invited to participate in COIL consultation due to its important role in representing small business. So the department held that consultation session on a limited exposure draft of the bill on the 2nd of July 2025 with that Committee on Industrial Legislation and COSBOA. Invitations were sent on the 27th of June 2025 to that virtual consultation session on the 2nd of July, and the department requested confirmation of attendance by the 30th of June. We're happy to walk through the standard process for that consultation, if that would assist, Senator.
Look, I think you've probably covered that off, and I just want to double check. So it was around 3 union nominated reps and around 6 employer and industry reps. Is that about right?
There are seven union nominated reps, to clarify, and 7 employer representatives.
7, so equal representation. Thank you. That's probably the end of my questions. I might hand back to the chair, if I may.
Thank you. I'll pass the call to Senator Kovacic.
Thank you. Thank you for being here today. My question relates to business impacts, or my questions. Do you guys have any information, or has any modelling been done on the number of businesses that this will impact?
Thanks, Senator. So as part of any new policy proposal, we are required to consult with the Office of Impact Analysis. That is part of the Department of Prime Minister and Cabinet, and any new policy that has an expectation of compliance that would result in more than a minor change in behaviour for people, businesses or community organisations is required to have an impact analysis. As a result of those consultations with the Office of Impact Analysis, they considered that the bill does not meet the threshold for an impact analysis, as there would be no material effect on the status quo. And
So their judgment was that this was less than a minor impact?
Yes, and I can give you a few reasons as to why that was the case. This is because the bill focuses on the parameters of the Commission's decision making. So what it's doing is in relation to the parameters of the Commission's decision making. It doesn't impose any new regulatory obligations on employers, so there's no additional regulatory costs or no changes to the regulatory impost. The bill doesn't apply retrospectively, and also does not affect bargaining or the individual flexibility arrangements, meaning there is an avenue for negotiation on these issues with employees.
So just to clarify, they made the assessment that because it's around the parameters of what the Fair Work Commission can do, it's not necessarily impacting a business, even though the business will be impacted by the legislation. It's not a direct impact. It's just how the rules are being applied, which is one now via this legislation versus by the Fair Work Commission. Is that the logic of it? I'm trying to sort of understand.
Yeah, no, I'm just trying to think that through, Senator. So I think the primary reason is that there is no new obligations on employers, and it doesn't change the status quo. And it might be helpful here if I give an example in relation to my experience. So we've done quite a bit of reform in the last couple of years, and we made some changes to the casuals framework, and that introduced some new obligations on employers in terms of things they had to do to be in compliance with the law. And in that circumstance, we did an impact analysis. But this bill does not change the status quo for employers in terms of that they're still required to pay the penalty rates and overtime rates as they're currently doing now.
Yes, yeah. But the way that they can arrange their agreements with their employees changes.
Well, that was also one of the reasons.
Senator, I'd just clarify, it might just be a feature of language, but when we talk about agreements, we usually talk about enterprise agreements. So, on day one, as I heard the sort of discussion focusing, there will be no change for how employers enter into enterprise agreements.
And for me, agreements, and I understand it's not, union movement or legislative language. For me, an agreement is an agreement between an employer and their employee about what they want to do, and I think that's the challenge. There is an impact between those, let's call them flexible work arrangements, that an individual and their employer can enter into, and that will affect many small businesses.
I might just clarify that a little bit, Senator, to say that all modern awards and enterprise agreements are required to have a term that allows for individual flexibility arrangements, and that talks exactly to the circumstances that you've just outlined there. And the current clause in modern awards says that the type of things you can talk about in that one-on-one conversation to determine an individual flexibility arrangement are things like penalty rates and overtime rates. 134A subsection 2 expressly says that this bill does not apply to that, meaning that that can still continue as it currently does.
Okay. The other thing I was a bit confused with, and I may have misunderstood, you've made the note that this isn't retrospective. Did I understand that? Was that correct? Yes. The ACTU says on page 3 of their submission, the amendments will also apply to awards made before the legislation's commencement. So isn't that retrospective?
It's not retrospective, Senator, in the sense that it doesn't affect any of the provisions in the current award system unless and until there is an application before the Fair Work Commission to reconsider any aspect of that award. So
they then won't be able to because of this legislation.
It means that this principle will apply.
Which means they won't be able to.
However...
is that correct?
Sorry, reduce penalty rates or overtime rates, absolutely. Section 135 capital A subsection 1 would stop a reduction in penalty rates or overtime rates in an existing award for an application that is made after commencement. Yes.
So if I just want to get an understanding of it. This is for my own clarity. If an employer and an employee came to a decision that this is what they wanted to do for, certainty of payment, flexibility, a whole range of things, they cannot do it under the terms of this if it appears, based on a particular calculation, that the penalty rates are effectively being reduced, or is that not the case?
They could do it through an individual agreement. So the employer and the employee could enter into that individual flexibility arrangement. Yes.
Agreement.
For that employee, yes. Right. And that could have the effect of reducing the penalty or overtime rates.
And could you explain to me what the process for that would be? What would that look like? So I'm a small business with 2 employees, and one of my employees, a single mum with 3 children who is saving for her first home, and she needs to have stable and regular income for her home loan application rather than penalty rates over certain weekends. So she's come to her employer and said, can we do this? And they want to enter into this agreement. What do they need to do?
So that's generally set out in each individual award, Senator. So that's where we struggle a little bit with entering into hypotheticals in these scenarios.
Let's go with the, let's say that somebody has a small, let's pick one. Let's say it's a cafe. Yeah, let's pick a cafe. And I have no motive. I'm just trying to understand. Like, I'm not trying. I don't have any preconceived agenda here. I just want to get an understanding of what the small business owner with 2 employees needs to do that's already working 12 or 13 hours a day.
Yeah, so at a very high level, Senator, that small business owner would know what an award implied to them if they were paying their employees under it. And as Ms Williams has set out, Section 144 of the legislation already requires all of those awards to have a flexibility term. The reason that we don't set out the process in the Fair Work Act is that enables that flexibility process to be tailored for those industries in those modern awards. So what I would expect that small business owner to do is to look up their award or to seek help from, for example, the Fair Work Ombudsman's Employer Assistance Service, which is specifically tailored to small business. To get some advice on what that award said in terms of how to enter into that flexibility arrangement. There are some requirements for award flexibility terms at sort of a broad level. So it must be sufficiently precise to outline what the terms and conditions are. It must result in the employee being better off overall. And it must be sort of genuinely agreed.
Overall is a financial parameter, correct?
It is a broad test, Senator, so it can take into account financial and non-financial matters, but it's designed as a sort of a global test, if you will. And it also requires, for example, that the employer must give a copy to the employee, so everybody knows what the terms are. They're clearly set out.
Okay, and that can be a private arrangement between the 2 of them that doesn't have to involve any other party.
Yes, Senator, and it is that one-on-one arrangement that suits that employer and that employee, which is why we refer to it as a flexibility term or an individual flexibility arrangement, because the emphasis really is on flexibility in that scenario, that it's that those circumstances that, as you've outlined in this case, suit that small business and that individual employee.
And in terms of the resources that you spoke about at the Fair Work Commission, and this might be out of your remit, but I'm curious to understand how many small businesses access those services.
I'm sorry, Senator, I don't have that information off the top of my head.
Is that something the department is able to provide on notice?
We can certainly see if we can,
and perhaps
Senator.
The Fair Work Commission may be able to assist with
we can
that.
do that.
So
I wasn't sure if that's something that you have or they may be able to assist with. Okay, I think that was pretty much it for me. One of the questions, no, I do have one more. One of the concerns that have sort of come up a few times today is in relation to the interpretation of this legislation. The industry groups made a comment that in the consultation that you've described and the members that were read out, that they talked about some necessary changes to that legislation for clarity and to spell things out. Can you give us some sort of sense of why that wasn't taken on board and why you don't, or why the department didn't feel in the drafting of this that needed to be spelt out? And even earlier in the day, we had one of the other senators and one of the witnesses talking about, fairly literal reading or my own reading or this interpretation. I think probably, the last thing we need is, more industrial relations legislation that has grey areas in it or confusion around how to apply it.
Certainly, Senator. Thank you for the question. I think the first thing that I would like to make clear is that this was something that was very much in contemplation when we did the drafting. And we worked through the drafting very methodically with the benefit of the Office of Parliamentary Counsel, but also with stress testing that both internally with the experts that we have in the department and also with our external legal advisors. The bill, by design, incorporates a high-level principle into the Fair Work Act, and there are a number of advantages for having a high-level principle rather than trying to be prescriptive and set out every individual circumstance that may possibly be encountered. The first is that humans are endlessly creative. It's one of the virtues of our species, if you like, and it is often very difficult to think of every single scenario that could ever apply or be thought up or be dreamt up. And often we're not wanting to remove that flexibility, as we've just had that discussion, that actually having sort of flexibility and judgment and discretion built into the system is often a very significant advantage. And in this case, this principles-based approach gives a number of advantages. One is it enables the Fair Work Commission to exercise its discretion in individual cases based on the evidence and the facts and the applications that are brought before it. So by having a high-level principle, we haven't sought to really confine the sort of applications that people can bring before the Fair Work Commission. We've also left the Fair Work Commission is going to apply the principle not in a vacuum, as we can sort of struggle with sometimes in this sort of committee scenario where we're thinking about hypotheticals, but the Fair Work Commission will be applying it in a very real-world scenario with the benefit of evidence being put on by parties, with the benefit of a contested process where parties make submissions, put on evidence and test those ideas. And so the idea is that when a particular scenario or circumstance comes up, that there is the high-level principle that guides the Commission, and they're using their expertise with the benefit of all that evidence and submissions to come to a fair and reasonable outcome in the circumstance.
What the Fair Work Commission already does, though, aren't they already meant to be fair and reasonable?
That is certainly their role or their remit as they come to a fair and reasonable outcome in the circumstance.
What is the actual purpose of this legislation if they're already being fair and reasonable?
So at the moment, when the Fair Work Commission considers applications to make, vary or amend the modern awards, they're applying the modern awards objective in section 134 of the Fair Work Act. That objective contains a number of different principles in it. And sometimes those principles can pull against each other, and the Fair Work Commission is given the job of then assessing on the basis of all of those principles and the tensions inherent in the modern award objective, what is that outcome. What this provision does in this bill is put beyond doubt that the outcome cannot be that penalty or overtime rates are reduced. Whether that is directly or through a different arrangement, that whatever the real world outcome is, if you like, that the outcome must not be that those penalty or overtime rates are reduced or that additional remuneration. So it essentially reinforces that flaw that Ms Williams was talking about.
Yeah, essentially, I think I talked about a flaw, and I like to add its simplest. It's securing the flaw. It's securing the flaw for penalty and overtime rates for female-dominated, low-paid, more insecure workers. And I guess it also obviously clearly implements the government's election commitment, which was to legislate to protect penalty and overtime rates in modern awards to ensure wages do not go backwards or reduced.
And some of the evidence today has been that none of that is actually at risk. Any of the carve-outs that have been sought out have been for higher paid workers rather than for lower paid workers in terms of approaches to the Fair Work Commission. So would you know how many applications there have been, or this is likely a question for the Fair Work Commission, how many applications there have been to reduce penalty rates in specific agreements for, lower paid workers?
I think in terms of the number of the number of applications, we'd have to take on notice to see what information we have, Senator Kovacic. I think my colleague is just looking to see, in the Minister's submission in the retail award case, we did set out the sort of salary ranges that it would apply, and not all of them are what we would tend to refer to as high-paid workers. So some of them, my recollection is, and sorry, I think Ms Chong is just seeing if she can get to it, is that some of them were below that kind of median wage cut-off, but I'll just see if my colleagues can assist.
Sure, and that can be on notice as well. It doesn't have to be now. Yeah.
Just off the top of my head too, so there's obviously, I think I heard evidence earlier today that there was the 2017 decision that was part of the 4-yearly review of modern awards that reduced penalty rates, and then there is currently obviously 2 applications before the Fair Work Commission in relation to the Clerks Award and the Banking and Finance Award and the Retail Award.
Referenced today as being higher paid sort of managerial or executive salaries.
So, Senator, I have that information now. So a level 4 employee in the Retail Award, their current minimum annual rate is $55,556.80.
And applications have been made to reduce penalty rates for those workers. Is that what you're telling me?
Yes, and the 125% exemption rate would take that worker to $69,446. I'm sorry, I don't have the cents.
So the exception rate would give them a higher salary?
Well, that would depend on what penalty or overtime they otherwise would have accrued.
Right, but they may not. Well, so that rate's some $14,000 or $15,000 higher under the exception. So that, on face value, is an improvement, but we don't know what the penalty rate value is. And so how do we find that out?
So that was the subject of some evidence in the Retail Award matter, Senator. So evidence was put on by the parties. The ARA, or the Retailers Association, relied on hypothetical rosters. The SDA, the union, used a mix of hypothetical rosters and rosters of real employees to demonstrate what the impact would be. But I think this probably circles back to our conversation about having a high-level principle, having that allows that sort of discussion, if you like, to be had before the Commission, to have that evidence and to say in practice, are these people worse off, or are people worse off if they have an exemption rate? And some of that comes down to, is the exemption rate set at the correct level?
And were any of these workers actually having, high rates of working overtime or penalty rates, or a low rate as well, would actually come into play too. I have one last question, Chair. We had a discussion earlier with the industry groups, and I may have asked the union movement as well, I don't recall, in relation to work from home. Do you have any concerns, or did you do any modelling around potential unintended consequences in relation to precluding employers from being able to agree to work from home for their employees? For an example, if that employee took some time off by mutual agreement during the day and then decided to do a bit of work once the kids went to sleep, would this legislation perhaps suggest that a penalty rate would be applied when they did their 2 hours of work from 7 p.m. till 9 p.m. instead of from 3 till 5?
The first thing I would say, Senator, is my understanding in practice at the moment, the vast majority of that sort of flexibility around hours worked is actually, for award-covered employees, is actually set out in individual flexibility arrangements, which are not prohibited by this bill. And that is one of the sort of common practical ways that people enter into what we call IFAs, or those flexibility arrangements, is to be able to adjust their hours like that, which is certainly not prohibited by the bill. The principle's not expressed to impact award terms that influence how or when penalty and overtime rates are accrued, but this comes down to really this high-level principle and it not being applied in a vacuum. So when an application comes before the Commission, they will be looking at what is really going on, if you like, and that will be the subject of evidence and submissions. And we would expect that the Commission would come to a determination about what is really going on. Are penalty or overtime rates really being reduced, or are you looking at something else entirely, to which this principle does not apply, but you still have all of the safety nets in the modern awards objective.
So this bill won't change how the IFAs can apply?
No, Senator.
Not
so,
the intention of it.
Yeah, if I could take you to the drafting, it proposes new section 135, capital A. Subsection 2 says, subsection 1 does not limit the operation of section 144, open brackets, flexibility terms, close brackets, and that's the provision that contains the mechanics, if you like, for those individual flexibilities.
Even if they're no longer working unsociable hours, so it's regardless.
Oh, you can have an IFA as long as you comply with the terms in the individual award. There's no requirement that you be working unsociable hours to have an IFA, but I'm broadly in the framework. I confess I'm not across all of the flexibility terms in all of the modern awards, but I'd be surprised if that was a requirement.
Yeah, we've got some more, but I can leave it to questions on notice. Yeah.
I was going to say, the Fair Work Commission is actually required to report on IFAs every 3 years in the General Manager's report, and the most recent one was in November 2024, and they did a survey to inform the information there, and of the employers surveyed, one of the things, the equal highest thing that was changed as a result of an IFA was overtime rates and a change in start rates. And of the employees surveyed, some of the highest things that were subject to an IFA was, again, changes to start and finish time. So that goes to kind of what you were talking about, and changes to working patterns and hours. So that kind of shows how they're used, and the Fair Work Commission General Manager reports on them every 3 years.
Thank you, Chair.
Thank you so much, and thank you very much for your evidence today, and as always, your participation in our committee's work. Questions on notice are due back to us by the 15th of August. But that does conclude today's hearing. Thank you to Broadcasting, to the Secretariat and to our friends at Hansard for all of your assistance as well. The committee stands adjourned.